Good morning, Ms. Rivers. You able to hear us?
Good morning. Yes, I am.
Fantastic. Well, let's get started. This is position 12 on the status conference, soon to be renamed final plea calendar. It's State versus Shalacia Benton, who is here, 22 SC 183599. She's represented by Ms. Rockwell. Mr. Jordan represents the state. Ms. Rockwell, I'm going to let you get on the record your thoughts about this unindicted case. But for this case, in which Ms. Benton is charged with aggravated assault and possession of some kind of weapon, do you have all the discovery, any discovery issues?
I think I do, unless you think I don't. I mean, I don't think he's held anything back. And, you know, obviously,
You're not aware of it. You haven't looked at the police report and it says, oh, Ms. Benton gave a statement and you don't have that. You're not aware of any missing discovery.
Correct.
Okay.
Only thing missing is, you know, what's missing. We need that other case.
Okay. But for this case, you've got the discovery. Mr. Jordan, are you aware of any discovery you've been waiting on? Surveillance footage, anything like that?
No, Your Honor, I do believe that the discovery, I think it was sent in October of 2022, has all the discovery, which would be body cam footage and surveillance footage from the incident location.
Okay, great. So what is the state's offer right now? Should Ms. Benton want to resolve this case today?
Just this case, Your Honor, the state's offer would be 5 years to serve one on this particular case.
Okay. And I don't know, that's credit for time served. Ms. Benton's on bond now, but it would be credit for whatever time she's already served.
She would receive credit for the time that she served, but we wouldn't intend to commute that sentence right now, Your Honor.
Okay.
I didn't hear the last thing you said. We wouldn't.
Would not ask for it to be reduced to time served. So the state's offer right now is serve 1 year followed by 4 years on probation. What are the unindicted charges?
Your Honor, that's 21 CP 204237. That is a single count of aggravated assault, family violence.
Different alleged victim?
Yes, Your Honor.
Okay. Are you coordinating with Ms. Willingham on that one?
Your Honor, I believe that last time that we were in court, it may have been a Mr. Wittenauer matter, and that we were trying to coordinate to get that case green sheeted.
Okay. Of course, coordinating to get it charged and then green sheeted.
Yes, Your Honor.
Got it. Okay. So Ms. Benton, as I understand it right now, if you were to resolve this case, which is the only one you can resolve, the other case hasn't been charged, despite your lawyer's best efforts to get the state to speed that up. Let me pause. Ms. Rockwell, has Ms. Benton executed a waiver of indictment so that the other case could be accused, or is her case stuck in that long line to the grand jury room?
So that's what we discussed this morning. Would he be willing to just accuse it if I signed a waiver of indictment? Some DAs think that some cases have to be indicted. I've gone back and forth with different thoughts, and
so the law is that, short of my understanding of a capital crime, a defendant can waive her right to indictment if she and her lawyer decide that's in her best interest. This is far from that. And so I'm confident that legally the district attorney's office could accuse the CP case. Whether they choose to for policy reasons, you and I are stuck. I don't know. And that may be where you run into differing answers from different ADAs. But certainly, if you were to execute on behalf of your client a waiver of indictment, the state would be empowered to accuse this other case. And then it would get green sheeted here, and Ms. Benton could resolve them together. Today, that's not where we are, but that would be more reason for you and Mr. Jordan and maybe Ms. Willingham to stay in contact. We've already reset this once, right, because supposedly this was going to happen and it hasn't. So we're going to move Ms. Benton's case, this one, to a trial calendar. I'm hearing you say that it likely will resolve short of trial. We'll see. But let me get Ms. Benton's response to this offer from the state. So Ms. Benton, you understand that if you were to enter a plea today to the case that is indicted, which make sure I am looking at the right thing. There it is. This is the case where you are accused of pointing a gun at Mr. Chestnut, just so we're not confusing the two situations. This case, it alleges you pointed a gun at Mr. Chestnut. If you were to plead guilty today, the state would recommend that you serve 1 year in custody, followed by 4 years on probation. Do you understand the state's recommendation?
Yes.
Okay. You understand that Ms. Rockwell would not have to recommend that. She could recommend less than that. If I were to sentence you today to more than what your lawyer asked for, so I'm guessing Ms. Rockwell would ask for just straight probation, but you two would talk about that. So let's say she asked for 5 years probation. The state's asking for 5 years to serve 1. If I were to sentence you to anything more than what Ms. Rockwell recommended, today you could withdraw your plea. You could say, no, thanks. I was interested in what my lawyer argued for, but that sentence you imposed, Judge, that's a more severe sentence. And so I'm going to back out of that. And I'd like my case to go to trial. You understand that?
Yes.
After today, you're free to enter a plea. And it may be that Ms. Rockwell negotiates something with the state to resolve not only the Mr. Chestnut case, but this other one, and would go forward from there. What you cannot do after today is, if you don't like your sentence, back out of it. So just do a hypothetical. Let's fast forward to the June trial calendar, which may have this case on it. You know what? I don't want to go to trial. Maybe there's video footage of you pointing the gun at Mr. Chestnut. I can't beat that. They're going to see me on film. So I want to work it out. And Ms. Rockwell argues for a sentence. Mr. Jordan argues for a sentence. I'm going to give you the sentence that I think is appropriate based on your situation, your background. There may be input from Mr. Chestnut, but that sentence is one that you have to go along with if we take the plea after today. Today, you can back out if you don't like the sentence and it's more than what Ms. Rockwell says. Do you understand all that?
Yes.
Okay, understanding all that, do you want to go forward with a guilty plea today, knowing what the state's going to recommend and knowing that it only resolves one of your two cases?
Judge, could we visit?
Sure, you all should visit, and we can tie this up. Are there other things you want to get on the record concerning this status conference before we pause it and you and Ms. Benton talk a little bit more about her options?
Not exactly right now, though, Judge, but I did look in my past history, and I'm just forwarding it now to Deidre and also to Mr. Jordan. On February the 21st, I did sign a waiver of indictment and sent it to Mr. Whitenauer on the other case. And so I don't want you to think that we're sandbagging, and I know the DA's office is real busy.
I'm looking at it right here. You filed it on the 21st. You signed it. It's got Ms. Benton's signature, and it's a matter of public record. So you took the steps you needed to take. Of course, the state's not obligated to do anything with that other case. That's the dilemma Ms. Benton is in.
Right.
And it did probably hit the docket as there was the transition from Mr. Whitenauer to Ms. Willingham, whether she was aware, Ms. Willingham would have no reason to be checking the CP docket.
Right.
And unfortunately for Ms. Benton, it's a different ADA who's got this aggravated assault.
Right.
So it is a bunch of overlap, and I wasn't attributing delay to you. We need to move the indicted case forward. You and I, in many instances, have waited and waited and waited for a case to get charged, and that doesn't always happen. This case has been charged, and so that wait period is over. If between now and the trial calendar, the state can or chooses to, it's again their call, accuse the CP case, then all the pieces will be in place for a global resolution. But it may be that's not what the state wants to do, and that's not a bad choice on their part. It's a choice.
But it's their choice.
Yeah.
So could we just do this before we all run off into the horizon? Could I ask her just to stand down and let me just keep working on this today? Unless, I mean, it looks like you might be waiting around for these inmates to come anyway.
I'll be here all day.
Okay,
So
all right.
I don't mind. I'm not gonna, and Mr. Jordan's gonna be here all day. So I think that's gonna work out. I'm just checking.
Your Honor, if I may, if it's any consolation, I have actually requested somebody down. It's in CID case intake to get me the police report. So I am actively working. I was not aware of the waiver, but I am actively trying to put the moving part.
Okay.
in place.
And I want to be clear, this isn't your case, the unindicted one.
understand.
It's just floating out there. I want to make sure it was a different alleged victim. It is. It's a Mr. Ford.
That's
So
my son's dad.
Okay. That would be why it's family violence, aggravated assault. But two different people. And so it's going to stay as two different prosecutors. But that's what we'll leave it as. So what I'm going to do is pause position 12 and we will reconvene later this morning so that Ms. Benton can let me know. I understand what the state's offer is and I'm not interested going forward today. Maybe there'll be a global resolution or who knows what's going to happen with the Mr. Ford case. Let's take care of the Mr. Chestnut case.
So he just went to court for that like 2 weeks ago.
He being Chestnut or Ford?
For
He went to court, meaning,
because we both got charged.
oh, it's one of those situations. Oh, that'll be fun for the state. That may be one reason why it hasn't been charged yet, because some ADA in a back office looked at it and said, oh, I don't even know how to make heads or tails. I guess I should say this, Ms. Benton. Another thing the state may do is read through the report and say, we're not charging Ms. Benton. We're dismissing it.
Yeah, well,
Because it is a
family violence.
well, not because it's family violence. They've got plenty of those where your boyfriend breaks your nose and yeah, that's family violence. Your boyfriend needs to get charged for breaking your nose. But sometimes when it's what we might informally call mutual combat, well, how are you going to charge both people? Because you are the eyewitness, but your lawyer would say, don't talk about it on the stand because then you've been charged for the same thing. The state can't do anything with that. And that may be what they decide with your Mr. Ford case. Not my call, but that's another reason that you should be happy to hear that Ms. Willingham has said, I need to look at the police report. So
That report is all over the place.
Yeah, and
Okay.
I'm gonna let her not talk anymore.
all right.
But and that could have something to do with, I mean, we talked about her even being eligible for first offender. Maybe the fact that was out there drove
Who knows?
who knows?
I mean, if
So-
I were Mr. Jordan and I'm looking at it like, dang, there's this other open ag assault,
Right.
I view the Chestnut situation more seriously, but maybe if one scratches the surface more of the Ford situation, then it's murkier and whatnot. But I think that's right. Ms. Benton, you and Ms. Rockwell can talk a little bit more. Please, neither of you leave for the day until we close the loop on what we're doing with this case. Okay?
I won't judge. I do have Judge Carnicel. I was gonna go to her first today, but since I was here, I'm just gonna go and answer up there.
Okay.
And we'll see if we can kind of make some sense of because we have always felt like she was a victim in the unindicted case.
Okay. Well, the two lawyers you need to be working
Right.
with are right here. So why don't you talk more today and then I will see you and Ms. Benton later this morning. Okay? All right.
May I be excused?
Yes, ma'am.
Oh, yeah, I pulled up the CP.
Ms. Nelson, can you please provide an update from the sheriff's office? Thank you. All right, let's turn to Mr. Bruce, please. Mr. Bruce, if you and your lawyer would come up to the podium.
Good morning, Your Honor.
Good morning. It's good to see you not in orange or blue, whatever it was. All right. Let's turn to position 2 on our status conference calendar, State versus Asante Bruce. It's 22 SC 184765. And what I learned from looking at this case when I saw the calendar and was surprised, wait, I recognize this name. I just met Mr. Bruce. And these weren't the charges that we were talking about, is that the indictment in this case doesn't match up with what is in Odyssey. And of course, the indictment controls and not Odyssey. Mr. Bruce is charged with 2 misdemeanors, no felonies. I'm not quite sure how that ended up in Superior Court, but it may be Mr. Jordan covers that. But more importantly, Mr. Bruce, your lawyer tells me that you're prepared to enter a plea to these charges today. Is that correct?
Yes, Your
To
Honor.
one charge, Your Honor.
Okay, however, it's been negotiated. The way this is going to work is Mr. Jordan in just a moment is going to put you under oath. Once you're under oath, it's important that you answer his questions and mine truthfully and completely. It is just as important that if you have any questions or there's anything that happens that is confusing you because it's not going the way Ms. Glaves-Innes said it was going to go, that you let her or me know so we can work through that, okay?
Absolutely. Yes,
All
Your
right.
Honor.
When you're ready, Mr. Jordan.
Thank you, Your Honor. Just for the record's purposes, this will be a plea to only count 2, which is carrying a concealed weapon. The state, you guys move to dismiss count 1 due to the faulty indictment and to avoid any confusion about what Mr. Bruce is pleading to.
Oh, that's right. I should have made it clearer. So the indictment on its cover says fleeing and attempting to elude, and that's what ripples all throughout Odyssey. That would be a felony, but the actual text of count 1 is reckless driving, and even there in all caps, misdemeanor. So there was a disconnect in the processing of the indictment. Regardless, count 1's being dismissed. So we're just proceeding with carrying a concealed weapon, also a misdemeanor.
Yes. Mr. Bruce, can you please raise your right hand?
Excuse me, Mr. Jordan, can you pull the microphone in front of you?
Sure, my apologies. Can you hear me now?
Yes, thank you.
Okay. Mr. Bruce, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name?
Asante Tajay Bruce Jr.
And can you spell that, please?
My first name would be A as in apple, S as in Sam, A as in apple, N as in Nancy, T for Thomas, E for elephant. Tajay would be spelled T as in Thomas, A as in apple, J as in Jack, A as in apple, E as in elephant. And my last name would be spelled Bruce, B as in boy, R as in rabbit, U as in umbrella, C as in cat, E as in elephant.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
I'm 21 years old today, and I'm actually still in college at the moment.
Okay. Are you
And today's your birthday? Or today you are 21, tomorrow you're 21?
Yes, it's my birthday is in October. I'm 21 today,
Okay,
as of today.
okay.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with the offense of carrying a concealed weapon?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney, Ms. Glaves-Innes, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with her services?
More than satisfied, sir.
And Ms. Glaves-Innes, do you waive formal reading of the indictment?
So waive.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Bruce's name?
Yes, I do.
Mr. Bruce, do you recall having been arrested on these charges?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Glaves-Innes, do you know of any outstanding warrants related to these charges?
I do not.
Mr. Bruce, has your attorney advised to you the minimum and maximum sentence for the charge that you are pleading to?
Yes, sir.
And just for the record, Your Honor, since this is a misdemeanor, the minimum is 1 day and the maximum is 12 months. Mr. Bruce, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, as previously stated, the state is moving to dismiss count 1 due to the faulty indictment and the language in the indictment not matching the particular count that's enumerated on the first page. The state for count 2 would recommend, Your Honor, I had Mr. Bruce in custody only for 2 days on this particular offense, but he also served 37 days on the unindicted offense that he has. So the state would the recommendation for this count would be 39 days to serve, credit for time served. And if that's too tricky, Your Honor, the state's recommendation would just be 2 days.
It's not that it's tricky. I'm confused. This conduct is from December of 2019. Mr. Bruce was very, very recently in custody. Was that just because it was a late arrest warrant because there was lots of investigation into the other case?
That is correct, Judge.
Okay, so, but Mr. Bruce served 2 days when he was arrested for reckless driving in December of 2019.
That's what I had, Your Honor.
Okay, and not right after that days in connection with the other charges. It would have been more recently when he was, okay, then I don't believe they're connected. And so I think the only time that would be properly allocable to this case would be the however many days Mr. Bruce was in custody after having been arrested for the bad driving and having a gun.
Understood, Your Honor. So the state would move forward and ask that the negotiated plea be 2 days to serve, credit for time served, Your Honor.
Okay.
Was that the negotiated recommendation that was communicated to you, Mr. Bruce?
Yes, sir.
Do you understand that the court can sentence you to the maximum on this charge?
Yes, sir.
Are you currently on probation or parole?
Yes, sir.
Are you a United States citizen?
Yes, sir.
And my apologies, you said that you are currently on probation?
Yes, sir.
Okay, do you understand that your probation may be revoked based on you entering a guilty plea today?
Yes, sir.
And are you a United States citizen?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you were giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you, or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
Mr. Bruce, how do you plead to the sole charge of carrying a concealed weapon and indictment number
22 SC 184765?
Thank you very much.
You bet.
I'm sorry, I plead guilty in the Alfred plea.
Thank you. Are you pleading guilty under North Carolina v. Alfred because you have decided that it is in your best interest to do so?
Yes, sir.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, sir.
Is this guilty plea under North Carolina v. Alfred freely and voluntarily given with the full knowledge of the charge against you?
Yes, sir.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that since this is a misdemeanor that you are pleading to, you have only 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Ms. Glavis Ennis, did you inform Mr. Bruce of his deadline to file a direct appeal?
I did.
Thank you. Your Honor, if this case had gone to trial, the state believes it would have shown beyond a reasonable doubt that on December 2nd of 2019, an officer from the Georgia State Police observed a gray Nissan moving slowly with hazard lights activated. The troopers did attempt to pull over the vehicle when they noticed that the Nissan was operating in a reckless manner without regard for safety of that trooper, innocent motorist, and law enforcement pursuing. The trooper observed the Nissan going at well over 100 miles per hour. Once the Nissan reached Maynard Terrace, Maynard, Terrace has normal spelling. The driver maneuvered onto the ramp and recklessly through the gore of Interstate 20 East. The officers were able to eventually pull the vehicle over after the vehicle struck a utility pole. A weapon was found inside of the vehicle. That concludes the factual basis for this case, Your Honor. We would ask, Your Honor, that you accept this negotiated plea. This is, of course, an older case with the incident date almost being 4 years ago. We also understand that the indictment was written very poorly in this situation so as to avoid where the state is trying to re-indict a case that's over 4 years old, that we believe that this is a fair negotiated resolution. Your Honor stated before that Mr. Bruce has another pending case that is much more serious than this one. So we believe that closing this case and allowing Mr. Bruce and Ms. Glavis Ennis to focus on the more serious matter is in the best interest of judicial economy.
All right, let me look up one thing. So these misdemeanors occurred on December 2 of 2019. The statute of limitations has run on these misdemeanors. Had it been a felony, it would have worked. But I'm sorry, I didn't think of that earlier, but I was processing this as you were describing the case. I thought, why was Mr. Bruce not charged with a felony? And on the surface of the indictment, he was. If there was driving over 100 miles an hour, that's the reckless driving and fleeing and attempting to elude. That would have been the felony piece. But for whatever reason, that didn't make it into the indictment. But I can't take a plea on either of these because the state court had until December of 2021. And this indictment was handed down in September of 2022. Had a felony made it into the indictment, that would have survived. But really, Mr. Bruce should, through counsel, be arguing for a plea in bar. I'm not doing his work for him, but this plea would be a nullity. I appreciate that you structured it in a way that was going to have minimal impact for Mr. Bruce this many years after this situation. Not that his life has been spotless since this situation, but we need to not take the plea, and I need to dismiss the matter because of the statute of limitations.
Understood, Your Honor. Would you like the state to prepare that dismissal, or is it fine for it just to be on the record?
We need something in there. So if you don't mind, just flagging that, it's dismissed because the prosecution wasn't commenced. I'll give you the statute if you want to write it down. It's 17-3-1 subsection E. Prosecutions for misdemeanor shall be commenced within 2 years after the commission of the crime. And I didn't hear anything about this case such that the crime was hidden from view. This was a very, assuming the allegations could be proven, a very public crime. And GSP knew on December 2 that Mr. Bruce had done all these things. And it's not a knock on GSP. It's just this case got stuck in a queue. And the hiccup wasn't so much the misdemeanors, that just a felony didn't make it into the indictment. That would have saved at least the felony count, but not the misdemeanors. Mr. Bruce, this has been awkward, but you've been well represented. I can't sentence you to a misdemeanor crime that occurred more than 2 years after it was, more than 2 years before it was indicted. And that's what happened in this case. I think the state thought they indicted you for a felony, but they didn't. It was 2 misdemeanors.
We appreciate that, Judge, because we just talked late last night and I found out it was not re-indicted because the last time I was here on the other matter, it was announced. I am fine with that, Judge. I appreciate it. Just spoke with Mr. Jordan last night and realized that
Sure.
it was not re-indicted. And so here we are. I appreciate your Honor's ability to help us to sort this out.
Right. Well, I'm just doing what the law says. Mr. Bruce, you are on bond for much more serious charges. It's important that you comply with those conditions, that you stay in regular contact with pretrial services. They need to find you with no difficulty, not with lots of difficulty. Okay?
Yes, Your Honor.
Any questions about that bond?
No, Your Honor.
Okay. All right. Where are you in college?
I believe it's my second or my third year in college.
No, like what college are you in?
Oh, University of West Georgia.
Okay. And so you're back attending in person again?
No, I'm online.
Oh, it's virtual.
Yes, sir.
Okay. Well, good. All right. Mr. Jordan, anything else about Mr. Bruce's soon to be dismissed case?
Nothing further from the state.
All right. Ms. Glaves Innes, thank you for being here. Mr. Bruce, your unindicted case, if it ever does get indicted, is going to be randomly assigned. So I may not see you again. If it comes here, that is just chance. There are 15 different judges, of which I'm one, who could get that case. All right.
Yes, sir. Thank you
Thank
greatly,
you.
Your Honor.
Take care.
Thank you, Your Honor. May I be excused?
Yes, ma'am. All right. The inmates are close. I got an email a few minutes ago that they were 5 minutes out. Will you get you're listening? Okay. Well, let's work. I've got several bond cases on here. Folks need to be here by now if they're on bond. How about Will King?
Mr. King's here.
Hey, Mr. King. Yeah, Ms. Wood was on briefly. It's okay if she signed off.
And I don't know if she relayed her message to Ms. Feely. She didn't tell me she was logged off, but she did email me during the calendar regarding Mr. King. Did she?
Oh, she's having computer problems. So
Okay.
Ms. Wood may be back on.
She left the office. She did not realize she was gonna be testing positive for COVID, so she doesn't have this club. So we're working to get her back in business, but I know she.
And before I spoke for Ms. Woods, I wanted to make sure Ms. Feely didn't have what she was saying in regards to it, but as of this morning when we spoke, she had not actually had a chance to speak with her client to relay the offer that the state made. So she wanted to try and see if we could get it on another calendar.
When did the offer get made?
Your Honor, that is on me. It did not get made until this week.
Okay. And so Ms. Wood's been working through her situation, and it wasn't that she sat on the offer for a few weeks.
No.
She didn't get the offer until this week. Today being
Well,
Tuesday.
Well, maybe Wednesday before I left, but we both were in and out.
Okay.
So
Um, why don't we, because Mr. King is here, I know Ms. Feely is not the lawyer with whom he's been working most closely. Let's at least have a conversation, because Mr. King may say, let's do this now. And he may not, and then we'll let him talk with, he also may say, I would never do that. And then we don't need to bring Mr. King back to say that again. So, Mr. King, what I'm going to do, we're going to take a break in a little bit while the inmates are coming up. I'm going to have Ms. Feely talk with you about what the state's offer is. And you've got three options. One is, that's great, let's do it. The other is, I know I would never do that. And the third is, well, this just hit me. I'd actually like some time to talk with Ms. Wood, with whom you may have a closer relationship. I'm fine with all three. It's not on you that you're just hearing about this offer. And so it may be in here you decide, I might do that, but I need time to think about it and talk with my lawyer. I'm all right with that answer. I just want you to be straight up, because you may hear what the offer is and say, not in a million years. Then we don't need to bring you and Ms. Wood back in 2 weeks for you to say, not in a million years. I don't know what the offer is. I don't get in the middle of that, but sit tight, and Ms. Feely will meet with you in just a few minutes. Okay. Thank you. All right, that's Mr. King. Also on bond is DeMonte Williams on bond. I don't have anything listed under him.
He is in Cobb.
Oh, he's got two cases. I have that, and they're bringing him. He may not be in this first batch, Cobb not being Rice Street. And Ms. Benton, we talked about. How about Ms. McBurrows?
Good morning, Your Honor. Marcia Mignot on behalf of Ms. McBurrows.
How are you, Ms. Mignot? I heard your name on the radio this morning. You're famous, maybe infamous, depending on what people. I'm intrigued by it. I think that's fascinating, and sometime when we're not in a large group setting, I'd like to hear more about what you did.
Absolutely.
Thank you for getting involved with Ms. McBurrows' case. There was a time when she had no counsel, and that was frustrating for everyone. But let's talk about her situation. Do you have all the discovery in the case?
I just saw some e-file yesterday afternoon, Judge, and in all fairness, I had 4 conflicts yesterday, so I have not looked at the discovery, but it did drop yesterday via email. Today I see that she's on the plea and arraignment calendar, and I can formally waive.
Oh, that's right. All this is, I thought it was a status conference. So let's take a step back. There's actually time for the state to get you more. So let me ask the simple questions. Are you waiving arraignment for Ms. McBurrows?
Yes, sir. We're officially waiving arraignment. We've already filed motions, but we're respectfully requesting 10 days to particularize those motions once we get an opportunity to review this.
Sure. So I don't think I know you and I haven't worked together before. In my division, the way things flow, there's a waiver of arraignment form I'll ask you to fill out in a moment, and then you can leave that with me and I'll get it e-filed. That waiver, or a formal arraignment, but we're waiving, will trigger a scheduling order that will go out. So e-filed, you'll get the scheduling order. The first deadline is for the state to get you the rest of discovery. Not until that deadline does your motions clock start, because how do you know if you need to suppress a statement if you don't know if there was a statement? So you'll get the rest of discovery, and it may have hit the docket yesterday. Mr. Jordan's going to tell us in a moment. But after you've received that discovery, you'll have a certain number of days to particularize any motions. If you file any motions that I think require hearings, that date's on there as well. And then the final thing is the final plea date. And so I will see you and Ms. McBurrows again, either at a motions hearing for a motion to suppress, whatever it might be, or at the final plea, which is what I thought most of this calendar is, just that. But unfortunately, through no fault of Ms. McBurrows, her case, which is a little bit older, it moved slowly because she fell into that C2 category and Mr. Johnson hasn't been available. But you're on the case, which is great. So if you're waiving arraignment, then you can fill out the waiver of arraignment form. Ms. McBurrows, I want to make sure we've got good contact information for you in the system. I've got an address on Buffington Road. That's good. 2703 is the apartment. Excellent. That's where you're going to get notices. Ms. Mignot is also going to get notices, and she'll call you, but the important thing is they'll go to your address as well. And it will be to come to court for whatever's next. That won't be for a while, but most of all, you've got a lawyer now and she'll keep you posted as to what's going on. Do you have any questions about anything? Mr. Jordan, any updates on discovery in this case?
Your Honor, I sent out at least initial discovery yesterday. Ms. Mignot is correct about that. I haven't sent out an offer yet, but I do understand that her co-defendant has already pled, I believe, on this case, unless I'm confusing this case with another.
No, he pled on December 2 of last year, non-negotiated plea. So Mr. Sexian resolved his case and is out of commission for a little while. And so you're in a position to sort this out after Ms. Mignot has had a chance to get up to speed.
Yes, Your Honor.
Okay. So this will appear next either on that motions date that'll be in the scheduling order or that final plea date. So when you say initial discovery, it's all the discovery you've got. You just had no one to send it to until we fortunately got Ms. Mignot involved in the case.
Yes, Your Honor. I just wanted to make sure that there was nothing that was left out. So I did an initial review, and it's body cam footage and some other things, but I wanted to make sure. I didn't want to say that that was complete discovery.
Okay, got it.
Your Honor, we've completed the waiver arraignment form.
Great. If you'll just get that to me,
First, Judge.
you may. Thank you so much. All right, Ms. McBurrows, Ms. Mignot will let you know what's next, but also we'll get something in the mail to you, and we'll see where the case goes. Thank you both. You are free to go.
Thank you, Judge. Enjoy the rest of your day.
You too. Trenton Brown. We've shifted to plea and arraignment.
Judge, I'm sorry. I have a victim's family here on position 4, Tawana Stillwell, and I believe the defendant is in court as well.
Oh, okay. Well, we can do that. I was looking for bond cases and skipped over that. Let's do that. Position 4. So that's your case, not Mr. Abate's. And Ms. Edwards? Ms. Stillwell? Yeah. Okay. Great. So Ms. Stillwell, if you'll come up to the podium, please. All right, sorry to be bouncing around, Ms. Rivers. We're gonna go to position 4 and I need you to take this down, please.
Okay, I'm ready.
All right, this is 22 SC 185-080, State versus Stillwell. Ms. Stillwell is here, along with last name Marks.
Yes, Your Honor.
Mr. Marks, and you work with Ms. Edwards?
Correct, Your Honor.
Great, okay. Ms. Willingham is the prosecutor on the case. Mr. Marks, what we're doing today, this may be the first status conference, which I really should be calling final plea, that we've had together. I need to make sure you've got all the discovery and,
Your Honor.
okay, great. So you've got all the discovery that you're aware of. Ms. Willingham, is there any discovery that you know is pending and you flagged it for Mr. Marks, but the state doesn't have it yet?
No, Your Honor, we actually are in a position where I think this case is going to resolve. We've discussed it, and I know that the state plans to reduce the charge, and it is my understanding the defendant will then be entering a plea. We are not negotiated as to the sentence, only as to the charge. The state will make its recommendation, and I anticipate defense will make theirs. I know that when I spoke with Mr. Marks, he mentioned that he wanted to try and set it out 60 days. And that's where we are at this point.
Sure.
Your Honor, there has been a change in plans. I spoke with my client, and since we last appeared in court, she wishes to retain new counsel and take the matter to trial.
Okay. So Ms. Stillwell, that's your right. You can have any lawyer you can afford. And if you cannot afford a lawyer, I will appoint one. So you'll always have counsel if you want counsel.
Okay.
What you don't get to do is slow things down. I'm not saying you're trying to do that, but you don't get to slow things down because you switch lawyers. And here's what I mean by that. And I appreciate Mr. Mark sharing this with me. You are free to bring a different lawyer or group of lawyers on board by hiring them. But that lawyer is going to need to be ready to go to trial because that's the next stop for this case. It's not right away. It's a couple months down the road. But what I won't do is grant a continuance to your lawyer if he or she comes in here and says, gosh, I'm brand new to the case. I need time to get ready. Mr. Marks and Ms. Edwards are ready. They're familiar with the case. And if this were to be a trial, I suspect Mr. Marks would say, great. Great may not be the right word, but he'd say, we're ready to go to trial. This would likely be on our June trial calendar. So that's not right around the corner, but it's not too far away. So I share that with you just because you're going to need to be very open with a lawyer bringing on board that he or she is going to need to move quickly to be ready. Does that make sense?
Yes, I said that because I think if I was going to do the plea that they have me on, I'm not really understanding what's going on based off the evidence because
So I don't want you to talk about the facts of your case.
Okay,
but let me
have the 20,000 that they're asking for trial, so that's why I said I would need another lawyer.
Okay. Well, I don't want to get in the middle of your confidential communications with your lawyers. And I don't know anything. I know very little about the facts of your case. I know a little bit, but it sounds like your case has some aspects to it that are causing the prosecutor to say, there's a difference between murder when someone walks down the street, says you're in my territory and you shouldn't be, and shoots him in the head. And there's no basis other than the guy was on the wrong side of the street. We also have cases where someone has been routinely abused and is defending him or herself from the abuser. And that may start out as a murder, but it may get reduced to voluntary manslaughter or some other charge that does not carry with it a life sentence. And it sounds like to me your lawyers have been working hard to negotiate that kind of outcome for you by working with the prosecutor. And it sounded like from what Ms. Willingham said, that's the direction that this was going. If you choose to go to trial, which is your right, no one else decides that, the state's going forward with a murder charge. That's what you're indicted for. So what a jury would hear about is murder, felony murder, et cetera. Now, the jury still might say, we're going to find you guilty of nothing or a lesser included, like voluntary. But the difference between a plea where the state says we're taking murder and felony murder off the table, and a trial is that nothing's taken off the table. A jury might take something off the table, but the state's not doing it. And you don't make it happen just by saying, hey, you need to do this. Does that make sense?
Mm-hmm. And what was the sentence for the voluntary that they said?
I don't know. It sounds like it wasn't agreed to. And so I'm making something up now. I'm making this up. It could be that the state was going to recommend 10 years and the defense was going to recommend 5 years. And I'm making those numbers up. But what I heard Ms. Willingham say is that the two sides hadn't agreed, which typically means the state is at a higher number and Not surprisingly, your lawyers are arguing for a lower number. But they hadn't agreed on that. What Ms. Willingham was signaling to me was it's going to be not murder, but something less, probably voluntary manslaughter. That's the typical statute where it's a heat of passion killing. The classic example is you come home and your significant other is in bed with someone else. And you just are suddenly so angry and then someone's dead. That's still a crime, but maybe that's not murder because you just weren't thinking straight at that split second. Another example of voluntary would be this almost self-defense. I know what's coming because I've been beaten so many times. And then all of a sudden your significant other is dead. We don't need to work through that today because I didn't hear your lawyer or Ms. Willingham say, hey, and we've sorted it out for sure. What I heard them say was, it doesn't look like it's going to be a trial. The state is willing to reduce it for a plea. And that's what Mr. Marks and Ms. Edwards have been working towards. But you're the boss. And if you want a lawyer who's going to take you to trial, then
I would want to see what they was trying to work out then, if that's because I'm not sure what it was, if it was.
Okay. Well, why don't we do this? It sounds like today, which was the day for this to, if it was going to be a plea to these charges, we've passed that. If we don't sort it out today, I can move this case to a trial calendar. It doesn't mean that it will be a trial. That's just the next stop for it. What you need to understand, Ms. Stillwell, is that today, if you had entered a plea to a reduced charge, and I sentenced you to more than what Mr. Marks asked for. So remember those made up numbers. The state's saying 10 years to serve. We understand it was justified, but she still killed someone, 10 years to serve. And Mr. Marks says, let me tell you what Ms. Stillwell has been through year after year after year. And he recommends 3 years to serve. And I hear all this. I hear from the deceased family because there's two sides to every story. I might say, you know what, Ms. Stillwell, I think 5 is the right sentence. That's more than what Mr. Marks asked for on your behalf. Today, if that's what we went through, you'd be able to withdraw that plea and say, well, my lawyer said 3. Let's fast forward 2 months. You're on a trial calendar. It's going to say murder on the trial calendar, but your lawyers may still have negotiated a plea to this lesser. We'll go through that same process. The state's going to say 10. Mr. Marks may, and it's not going to be a surprise what he's asking for. He hasn't finished his negotiations with the state, because best for you is if they're recommending the same thing. But you may always be a little bit apart because the state's thinking, someone's dead here, and we can't agree to something less than, I'm making the numbers up, less than 5. Mr. Marks says, well, I'm going to argue for 3. I think there's a good reason. Well, I'm going to argue for probation, whatever he ends up thinking is reasonable. If on that date, after today, I hear all this and I sentence you to more than what Mr. Marks or Ms. Edwards had asked for, you got to go along with that. You don't get to withdraw. Today, you could withdraw. The only thing that's changing after today is that you don't get to withdraw your plea if you are unhappy with the sentence. That's how it works with a trial. If you are found guilty, let's say at trial, they find you guilty of that lesser offense. There'd be that same discussion. State says this sentence, your lawyer says that. I am the one in the end who has to come up with the sentence. You don't get to say, that's fascinating, Judge. I don't want that sentence. You're stuck. A jury found you guilty. You may plead guilty instead, and then we'd go through that same process. Now, I just said a whole lot. Do you feel like it makes sense now? Okay.
Understanding what's going on.
So what we're going to do is move your case to a trial calendar. That doesn't mean it has to be a trial. It also doesn't mean that you're still working with Mr. Marks and Ms. Edwards, but for now you are.
Yeah.
They're your lawyers of record. And until they file a motion to withdraw, and they haven't done that, and it may be after this conversation, you want to re-engage with them on this, but they remain your lawyers for now. This will go on a trial calendar. I'll answer your question in just a minute. And if you, through your lawyers, negotiate something where you want to do a plea, we can do that. You just don't get a back out of it if you don't like the sentence you get. Does that make sense?
Yeah, I do that, but I just was concerned about, I knew that I didn't have like all the details of what was going on. And then me and him we kept bumping heads because he probably was speaking, but I wasn't understanding the breakdown, what he was saying versus how you just broke down everything
Okay,
to me, but I didn't have the 20 for upfront.
okay.
Is what I was saying it.
Got it. Well, you and Mr. Mark should keep talking. And he will keep me and Ms. Willingham posted if he thinks that he and Ms. Edwards need to withdraw. But I'm hearing right now that you, Ms. Stillwell, are comfortable continuing to rely on Mr. Marks's services as your lawyer. Is that correct?
I do.
Okay. All right. Ms. Willingham, is there anything you want to add to this?
No, I think you covered it all, Judge.
Okay, Mr. Marks, I know that things are shifting rapidly here, but I want to make sure you understand where we are also.
I understand, Your Honor.
Okay, so I'll move Ms. Stillwell's case to a trial calendar. If before then you all have worked something out, we should do that. It is harder to take a plea on the eve of a trial calendar, and the state gets less and less interested in doing charge reductions the more and more work they're doing to get ready for trial. So you'll need to navigate that in a productive way. Ms. Willingham, is there anything, I guess I don't need to hear from the victim's family today because we aren't,
Correct.
today has
And
become just procedural.
I've talked to them about what today was going to encompass, so they were aware of that. I do believe this is already on the June trial calendar.
Okay. That's a draft calendar for right now, but you are able to peer into Odyssey, and Ms. Nelson had told me that cases that aren't resolved today will likely end up on that June trial calendar. So that's what folks should be looking for. That gives you still plenty of time, Ms. Stillwell, to work with Mr. Marks and Ms. Edwards to see where we end up. And again, I want to encourage you all, this won't be a real simple plea if it's going to be a plea. So we ought not to save it for the call of the trial calendar, just to give everyone the certainty, because if for some reason it blew up, then you'd need to be ready to go to trial. Okay. Ms. Stillwell, I want to make sure you and I have connected on this. Any questions about anything for me? You and Mr. Marks have some talking to do, but any questions for me?
No.
Okay, all right. Then you two are free to go, but I encourage you to have at least a brief conversation today based on what we just discussed. And I will see you at the latest for the call of the trial calendar, hopefully before then.
Thank you, Judge.
All right, thank you all.
Thank you. Have a good day.
You too. While I'm remembering, we are going to be specially setting Ms. Grant for a July trial calendar.
Yes.
I'll do that order today, hopefully, so you know that date. And then if you will send me again all the, because you don't have the right dates in it. You have the dates for the May calendar. And I sat on that. I didn't want you to be getting stressed about it. But we will, I guess that's Ms. Feely as well.
It is.
Excellent.
We were talking about it this morning.
Good. So I'll get that out so everyone knows that's the date. There'll be other cases on that trial calendar in case that falls apart, but that will be what will need to go.
Thank you, Your Honor.
You bet. Hey, Mr. King.
Ms. Wood is actually texting me now. She said she would be out sick until Monday, but she said she would like to speak to me regarding the offer and within my discovery.
Okay, then that's the right answer. And what we'll do, because she's out, is reset your status conference. So you're preserving your ability to enter a plea and withdraw it if you don't like it, because we don't have Ms. Wood here to give you her advice. So I'm gonna put this on your two cases on another calendar just like this. Okay, let me make sure we have. Eisenhower Circle?
Yes, Atlanta, Georgia, B54.
Yeah, all right. Where is that?
It's off of Jonesboro Road, about 285.
Okay, all right. We know how to reach you. More importantly, we know how to reach Ms. Wood. So she'll be in touch with you. When she's back in action, you guys should connect and we'll get this on a. Great. There's not that, it's not going to need to be that rushed because this won't be on another one of these for a few weeks. But the sooner you talk with her, the better. Maybe you guys can sort this out. All right, take care. Ms. Benton's coming back. Trenton Brown, still no Mr. Brown. All right, is that somehow conduct from 100 years ago? I can look. Indictment, it's a new indictment. No, it's not all that old. Okay, so bench warrant for Mr. Brown.
Yes, Your Honor.
All right. Craig, we dealt with, that's it for the calendar. So, sir, what are you here for?
I look up, he on the right, but they ship some stuff, it might take a week.
Okay, he will be here. He's gonna take a little longer because we had a little hiccup in getting the inmates here. But I got an email saying they're getting the Rice Street folks here. 5 minutes has passed a long time ago. Okay, and then they were gonna go get your brother. His lawyer's sitting right there if you guys want to chat. Okay, so we're stuck right now. I'm gonna go do some other things related to this. Let me see if there are any texts I got about anything else.
I think females here.
Well, anyone we can, well, other than Gonzalez, we don't need Gonzalez. That's.
Both of them will just.
Okay, great. I will come back out in just a few moments. Never had a misdemeanor dismiss statute of limitations. That little birdie went, wait, that's an old case for misdemeanors. I don't know what happened with that charging document. You're handling Ms. Gonzalez.
Yes, Your Honor, and that should be a plea, I believe.
A plea? Wow, all right. Hope we have something left on the trial calendar.
Two where it's like, I don't know, John would just like take the mantle and just like somehow where it's
Ever.
No.
You figure out. It's really hard.
Right, he would just
I
take.
got a whole lot of those purple and
I'm
not
fine with
interested in
keeping that
keeping
one.
ones.
I'm absolutely fine with keeping them, that's no problem. It's the same thing with Dominique Richardson too, because that's one where it's like. Yeah.
Well, it's good. I didn't realize.
Yeah.
That's good to know.
Yes, it is. It's helpful information because I was definitely confused about that.
Well, and that would have made me do these offers a lot sooner. Mr. Bateman has.
Grab that file, look for it, have enough time. If that's quick for there, I think I can make it back.
Well, I think you'll have to.
Yeah, that's true. That's true.
I don't think you have anybody here, so.
All right, then, I'm gonna run back and get Bateman's file.
Okay.
All right, after that. So you're ready to come on work? Oh. Oh.
There, but she actually was initially charged.
Oh.
He got 5 days.
Oh.
I think
That was a family too.
that was, my brother, which I got nervous. I feel like it was okay. She started talking about how she would be the aspect of the relationship. I don't think it was to the level that it was working. But that's what she got. I think whoever looked at it, they probably relate back to work and just probably turn it into the working. Of course, with those cases, it's always hard to get. I can't get around it. Yeah, but that's why I'm glad the judge explained it to her. From looking at her, like practices.
Right, and he's frustrated with her too. He's had to talk to her. He's frustrated with her.
If I were her, I would
Take that food.
yeah. She already was time before she had to actually enter the pool because she doesn't want to prepare herself to go in custody, which I understand. It's gonna go away.
No, but I was just gonna tell you that it's best not to say when they're on the trial calendar because unless you look the day that you come into court, there's most likely because I got them. They're tentatively put in there, but the way I kind of work is I look and see what has happened on our previous calendar, and then I might move them. If the calendar gets too big, I shuffle them around and move them.
That is good to know, and I also told Julian that I didn't realize the status.
He has been managed to find for the longest, so, anything you see. Status that he has already published.
I just feel bad because some of these offers I know I didn't get out too late, but I didn't get them out because I didn't realize that this was going to control. Forward. But now I know, so now I work according for the future, for the statuses that we have, I will work accordingly to make sure the officers are extended well before, to give them time to actually talk, so.
And I think with this calendar, maybe he'll give us some grace if we're like, they're on the fence, but they want a plea date instead of being pushed to a trial calendar, just to give us.
Well, and I plan to acknowledge it, that I didn't know. So that's a problem with all my, I don't have a problem, I'm the one that makes the mistake, I don't have a problem now.
Oh, yeah. I thought it was a sore dude. It's only when I have error. There's a plea, Miss Feely, that we're trying to schedule. I can't
Hopkins,
remember.
maybe?
Was
I
it
had a couple
Hopkins
of them. I had Hopkins and Tavante Williams. which
Yeah,
should be-
I was trying to get them this week, but that's not gonna work. Probably not. Now it's Tuesday, because I probably was gonna try to get them
This,
Thursday, but
Lacey being out really threw a wrench. in
That's
things. I was
true.
supposed to go to the jail yesterday and then I had to be, because she was
Okay.
gonna cover for it.
well, I think he's on, next week, I think he's maybe on civil. I have to look at my calendar, but I think he's on civil next week.
So it's possible we can, I would do it
Civil
for the
could only
day.
do a noon plea,
Okay, because they're
otherwise
both
it'll be
on.
the following.
Okay.
Well, thank you.
Better sheriff's office than Deidre being better than us today.
All right. What is it, they lost the calendar? They lost
Well, no, it was like actually on a clipboard right there.
it? Yeah. I mean, this afternoon.
We got there. I think I was. Well, he's not, well, he was there at 2:00. 1, 2. 3. 4, 5. 6. And then this episode. Yes. I didn't go over 15. Okay.
Both females are like.
You got nothing to females?
Both.
Who are they?
And it's Craig.
Well, Gonzalez, that's the plea, I mean, that's the motion.
So that's not.
Who's the other female?
It's Craig.
I bet you can go back, cause you had on.
He just wanted to bring out the talk to him.
Oh, okay. Okay, let me not get it.
We're gonna have to copy to hear you then?
Yeah, I think I would be like probably. Getting back to it.
Yes, it looks like it will. I don't know. I'll probably do it, but I will have to. I will.
Help me, bro. Like, you know, like, help me out.
Lee, as to, I don't know if I actually sent you the offer. I have one in mind, but I don't know if I sent it. Because I still, I'm waiting. Have you received medical records? I didn't think we had, because I didn't see them in the file, but I know sometimes when our files change hands, sometimes something has been sent over that maybe we just misplaced, but we sent it to you guys, so I wanted to double check. But I requested them.
Okay, so you don't have them yet?
No, I don't, that's why I was checking to see, I know sometimes we turn stuff over and somewhere, maybe somebody emailed it or something like that, and whoever didn't upload it or put it where it needs to go, so that the next person can see it. So I didn't know if we had them, I have requested them, because I did not see them. But I am, based on the history, it's still clear some time to let, because now all the things are set. And I know there is a bond motion.
Yeah,
And I don't know, maybe if I sent you something.
I think you did, because I think I saw him last week. This is what I talked with him.
Then if you.
So I'll talk to him about.
Oh, okay, then I changed it.
Okay.
Yes, what I wrote on here, then I wrote that, and then maybe I did something else, I changed that. And that's probably really right.
Cannot say.
And where was he with that?
He was gonna let me know today. He didn't sound super, like I'm not super optimistic, but.
But they.
Yeah,
He didn't
I
say
write
that.
notes on here, and then I forget to scratch them out, and I have adjusted them.
Because it's not even super as a county. It's all in here. That's wrong. They leave us. Well, because you said, no, it was really good, so. No, I gotta say, the word, it, and, okay. So this your regular job? Equal. So yeah, the school, we have the 8 years. Yeah, 8 years. Yeah, part.
What's up?
How are you doing? I'm good. How about you?
Not too bad for
Yeah, it's Tuesday. I can't believe it. Just been running on to week.
yeah, that's right.
Agreed to a tier one. Who is from the last year? You know, it's actually a nice official communicator.
I probably do. I'm gonna pull it up. Cause I don't think we got beyond
Just tier one.
tier one and tend to serve, you know, whatever else gets thrown in on top of that is gonna be, because she'll need to pull. And, yeah, my was served time for that reason. She's been in since maybe it's 22. No, I think it's August 22. I think I'm getting her confused with somebody else. Yeah, we've got, yeah, like I said, good afternoon, been forwarding back to you, or?
I think I was just looking at that when I was trying to look at my emails.
April 13th, she gave me permission to go down to tier one compliance minimum, that would be able to, so you get that completed. Then I said, okay, I didn't let you know, and then April 18th, I said, just talk to Rose, she'll take tier one offer, and put that on Tuesday. We'll need Spanish interpreters, so that's really great.
Okay, great. This thing started for some reason, or you?
Oh, yeah, 1004 sounds good.
Okay.
That would pretty much finish her off.
Okay, great. Yeah, definitely good information that she's already been into once. Suspended on her.
Okay, that works. Does, the only question I would have about, see now, I'm an interesting one, because sometimes it's better off to just have 10 on it, because that makes her parole eligible.
Okay.
After serving a third, which third 10 would be what, 3, 6, 9, 3.5. But lately I've learned that ICE, or at least I had a client where ICE refused to pick them up when they were paroled, so which results in them essentially being maxed out.
Right.
So not knowing what ICE's policy is, and given that she has prior removals for like he does, now I'm not sure if I take a 10 before, she'll probably go. Because on a downward departure, parole board reads it as you intended the entire thing to be served.
I found it. So what were you thinking would be
Just 10.
just 10?
But-
10 served.
Yeah, I'm gonna leave it up. I'm gonna talk to her about it and see, would you be willing to do either?
Yeah, 10 served sounds great.
Because I think she'll probably get out early, at least in my past experience, that's been what happens, is people usually paroled after 2 or 3 years
Gotcha.
on a
So-
tier one.
Gotcha, so,
If we do a downward departure of 4, she got to old.
and then we don't have to worry about them suspended or anything like that.
It would be, yeah, it would be parole more.
Yeah, I think 10 served sounds great. All right, that's better. Okay,
Unless you want to down to the park to time server.
right, no, I wouldn't
In
do
which
it.
case, okay,
Yeah, right, it's in the service house.
okay, cool. I'm more comfortable with that, just
Okay.
based on my past experience.
Absolutely understood.
Thank you. No, I just wondered if it had.
Yeah. All right.
I just wondered if it
Mhm.
So it would
It would have been indicted,
Yeah.
yeah.
So it could have, we made it, and had added on.
Right.
Don't hold it in the March.
Yeah.
They just click the wrong.
I think that they did, because the language in the indictment was.
For the felony, but it's, yeah, so they just.
Yeah, it's driving.
We. Let's.
Yeah, this
I did
was-
better than I thought.
This was what,
Oh, that was the one I
White
asked
House.
you about, that's what you know. Okay, and I think I emailed to see the taking that, the counter.
we do. That's last week. We like attending.
Victim. But let me call my victim.
Yes, how you doing?
I'm starting to think, you know.
Wow.
The courtroom.
So sorry, I'll contact the legal assistant about that one.
Who is that?
That's Anita Newsom.
What's last name?
Newsom, NEWSOM. Okay.
Those are the ones from yesterday. I think he has like two. Did you have one yet from yesterday? Yes.
How do you sound that?
I send the email to my legal assistant, and she just sends. I don't know what happened.
You ever received those either from yesterday?
I know, I don't know whether she did them yesterday or right away, because I typically she responds to me and tells me. Let's see, I'll check before I say she didn't.
And I don't know where they're, see, the problem is I used to have just one legal assistant in the office.
Yeah.
Then you guys changed it over to that, six. And I don't know who's on, I don't know how to do this, some doing this way, some doing another way. So I'm having more track.
I'm so sorry. Mr.
What's
Sanders.
up?
I have no idea why it's taking so long.
Brendan Harris.
And what's that one again? Second.
Anthony Kennedy.
So to her supervisor as well, because I'm not sure what it's.
Yes, she emailed and said they wrote down.
Okay, yours are done, okay, I'll go with it. Because they're supposed to send me an email to let me know they're done because unless. Let me look and see.
Well, and I will say that it has been my experience that they typically have sent them, at least when I was in complex, they would send an email to you all. But maybe now we need to do that. And that might be something that when she tells me there, then maybe I need to let you know. I just assumed that she did it because that was what I was used to.
Yeah.
So I'm with you, you know.
They just let me know
Legal
that-
system.
Okay, well, I'll go back and look to see if I can find it. I looked for that Anthony just before I came out here, because so I didn't
So sorry.
say, I don't have it yet. So I will check on yours and see if I can find them, and if not, I'll have you send them to me. Okay, thank you.
Good, how return. They probably want to switch it up, switch turns up. You good? Yeah, I'm good. All right.
I think so. No. I think I thought she went outside.
No, she's not.
Hey, how you doing? Yeah, same. It is. It's finally, let me see if the deputies are ready for us to go and talk with her. Get her signed up. It's a plea. It's not a hearing. Yeah, we cancel it. We're just gonna- It was a motion for speedy dismissal. Motion for dismissal. We lost. It was a good order though. Can't even be mad. I was going over these guys. I want to speak strong, but I don't want to try. I want to dismiss it. I don't actually try. So, it's all in love.
I thought it was gonna be a simple motion.
No, I mean,
Yeah.
Still control by it, so, you know. It's a good motion, it's just too. I think he might, I'm gonna ask the deputies. No problem. Hey, deputy. I got
I'm not sure if she's up yet, I'll just pop in there and talk a little bit fast.
She's up, but the deputy took the keys, once you come back.
Sounds good. Appreciate it.
That's also as well. I think that's gonna be the investigator there, no problem. That would be a trial. That's a very, very long one, so. That's-
I'm just assuming if you see the R in the I.
That's really shady.
Yeah.
Yeah, it's gonna be key.
Welcome to order.
Hello, everyone. Are the female inmates up? That was who arrived a while ago, was the people from across the street, not the people from Rice Street.
He's just, he's bringing up 6 of the male inmates now.
Oh, great.
So he just went to go get the males. He should be back up shortly.
Great. I will sit tight. What we're going to do is, oh no, I have to go find my calendar. Mr. Bennett, how are you?
I'm good, Judge. How are you?
Well, it depends on your answer to my next question. Mr. Jordan had previewed that Ms. Gonzalez's case might be a plea instead of the suppression hearing. Is that your expectation?
That is accurate.
Do you need to speak with her through Mr. Lares before we take the plea?
I do, yes.
Okay, once Deputy Gordon's up, why don't the two of you speak with her and then we'll take that plea. There's the other female I can just talk to at the door. Her lawyer already left. I just need to give her an update, assuming that female is Ms. Craig, but I gotta go find that calendar. And then once we take the plea in Gonzalez, we'll do the rest of the status calendar. Great, okay. Thanks, everyone. Things are coming together.
Can I step out? And take all of it?
Yes, sir.
Just so that you are aware, I didn't realize that status was final plea. So some of the offers were given fairly late. So I just want to give that.
That's understandable. For reasons we don't need to get into, I changed the name from final plea to status. And that has led to too much confusion about, well, is it also final plea? So you will see in calendars in the not too distant future, they're now called final plea calendars, and everyone knows what that means. So that it was a nomenclature mistake on my part, intentional. I changed it. It wasn't that I told Ms. Nelson on just one calendar. So if I believe that the defendant really does need more time to process all that, we won't have another status calendar. We'll move it to the trial calendar, but Ms. Nelson makes a note that the final plea rights are reserved. And that way we don't have to delay things with inserting another calendar in there. But if the offer was probation, then this is the day we need to work through it, unless that totally changed things and it had been, we're going to dismiss. Nope, now the offer's probation. Let me go find the calendar and then we'll get going.
You all right? Cool. You not? Don't leave? No? I'm just checking. Yeah, we'll do it again. Okay. Well, I appreciate that. Should you? No. All right, appreciate it.
I didn't speak. I just kept walking.
Just move forward. That's the best that you can do sometimes.
You talking about? Let me let him know.
Sure.
I told him he was coming up. He did? Yeah, but he just stepped off. You look with the calendar. Okay. He just stepped off. And I know he said that he wanted these two to speak with the young lady.
Let me get the attorney.
And then he said that he wanted to speak with the other.
Young lady.
He said he's concerned about that.
I have come from the side.
Yeah.
Okay, he's without
Hey, counsel, is there a blanking form I can? Yeah, it's over there on the bottom. Thanks. There it is.
Yeah, when we turn that magic switch. When we don't have or do have. So Alpharetta or there was someone who was in Alpharetta? Okay, cool. Do we know who that is?
Jonathan Huff.
Oh, yeah.
Huff.
He's for that.
No, actually.
Is he on the afternoon?
Yes, he's number 13 on that one.
Okay. Can you just let Ms. Nelson know so that, I don't know that Ms. Barnes knows that there was someone in Alpharetta.
She's the one told me.
Oh, okay. She knows, and they're getting him or they're not?
He's not here yet.
Okay, we're good. We'll work through that. All right. If you could please bring Ms. Craig to the door, just right there. We don't need to fill one of those out.
No?
No,
Okay, great. I'll just use it for reference then.
please.
Made it easy.
Hey, Ms. Craig, you can stay right there. I just wanted to give you a quick update. Mr. Bastian was here earlier today. You were supposed to be here earlier today, but we messed up and the whole pickup process has been running a little late. Mr. Bastian gave me an update. He is handling the case you and I have been working on, the one about the concealing the death of another and things like that. You have a second open case that's a shoplifting case, and Mr. Bastian is your lawyer on that. And he and Mr. Jordan, the gentleman over there, are working on a resolution to both those cases. The shoplifting is in non-complex, but I could take the plea if there is in fact a global resolution. And so Mr. Bastian asked that we get you back here and him back here in the next couple weeks to take care of that. I was willing to do that, even though it's time to move the case along, because he said he'd been making some good progress working with Mr. Jordan on your two cases. So I just wanted you to know that. Mr. Bastian said he talked with you recently, but he couldn't stay until the time we got you here. Not his fault. He was here on time. You weren't, but not your fault that you weren't here on time. So I expect that we'll be back together in the next couple of weeks. And I hope that what we'll do at that time is talk about resolving both your cases. Any questions about that?
What would I be looking for? Would I be able to get home to my child that I might lose or?
So that's a good conversation for Mr. Bastian. He will be, I am sure, arguing for a time served type sentence. I don't know if that's what the state's interested in. You have some complicated charges, not the shoplifting case. In the end, that's up to me, because I will hear from the prosecutor, I will hear from your lawyer, and I'll hear from you. You'll be able to tell me about your kid and how you want to get back, and I'll impose the sentence. We're not doing that today. And really, both your cases are kind of early in the process. I know you've been in for a long time, but your indictment is still a new indictment. I was pleasantly surprised to hear Mr. Bastian say, we may be able to sort some of this out. So I hope to see you in the next couple of weeks. And again, what I was hearing from the two lawyers is that that would be the time when everything would get resolved. Expect to see Mr. Bastian soon, and then you can ask him those important questions, okay? All right. Mr. Bennett, you need to talk with Ms. Gonzalez briefly. Great. If they could go with you, thank you. Mr. Jordan, is this a plea to the? Is it just one count in the indictment?
Yes, Your Honor.
Is it reduced or to as charged?
It's gonna be as charged, Your Honor, but we would ask that you accept the plea as to a tier 1 offense, even though this is a tier 3, I believe.
Okay. So we got an email today, Ms. Feely from County Public Health that said COVID incidences are at the lowest level ever since the initial outbreak. So some people have really bad luck. That was ironic. So we'll do the plea and Ms. Gonzalez, and then we can do Mr. Askew and Mr. Neesmith, Mr. Reed, Mr. Bateman. Those are all Willingham cases. Oh, great. Yep. Wonder if he got brought over.
I saw Mr. Clark has already been shipped to Department of Corrections.
Well, it's 3 or 6, so it's not like he's in the wrong spot. It's just a question for how long. So Mr. Neesmith shouldn't be here. He got out. So hopefully he's not here. Doesn't list active jailings. He was released on the 5th. You good? There's no Neesmith back there, is there? He was on the calendar, but he got released a while ago. Okay, great. All right, are you ready for Ms. Gonzalez?
Ready, Your Honor, yes, sir.
Ms. Rivers, are you ready?
Yes, I'm ready.
Great. Let's get going here. This is case 22 SC 184462, State versus Rosa Robles Gonzalez. She is here with her lawyer, Mr. Bennett. Mr. Jordan is here for the state, and I'm going to swear Mr. Lares, the interpreter, in. Mr. Lares, do you swear or affirm that you shall translate from English to Spanish and Spanish to English to the best of your ability?
I do, Judge, to the best of my ability.
Thank you.
You're welcome.
Ms. Gonzalez, I'm Judge McBurney.
Mi nombre es el juez McBurney.
We've met before, I know virtually, maybe not in person.
La conozco, creo que nos hemos visto por pantalla, no sé si ha estado usted en persona aquí.
I have asked Mr. Lares to translate everything that is said in English to Spanish for you.
Me ha pedido como intérprete que yo soy que traduzca todo lo que se vaya a decir en inglés al español para usted. Okay.
You may understand some of the English questions that are asked, but I need you to wait until Mr. Lares has translated them into Spanish before you answer.
Dice, quizás entienda usted el inglés que vamos a hablar aquí, pero él prefiere que no respondas, que esperes a que yo te lo traduzca al español para entonces responder.
Perfecto.
Perfect.
All right. Will you please let Mr. Lares or Mr. Bennett know if you have any questions at any time?
Déjanos saber durante este proceso si tienes alguna duda a mí como intérprete y luego al señor Bennett.
Muy bien.
Very well.
Okay. Mr. Jordan, when you're ready.
El señor Jordan va a comenzar.
Ms. Gonzalez, can you please raise your right hand?
Señora Robles, levante la mano derecha como pueda.
Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
¿Jura usted o afirma usted que la declaración que está a punto de darle a este juez en esta corte es la verdad, toda la verdad y únicamente la verdad?
Sí.
Yes, I swear.
Can you please state your true, correct, and legal name?
Danos entonces ahora tu nombre correcto, tu nombre legal, tu nombre verdadero.
Rosa Elena Robles González.
Rosa Elena Robles González.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
¿Estás consumiendo o tomaste o te dieron alguna droga por prescripción médica, alguna bebida alcohólica, alguna droga?
No.
No.
Is there a medication that you normally take that you have not been given today?
¿Hay algún medicamento que estabas tomando normalmente, excepto hoy, que no te lo dieron hoy?
No me lo dieron.
They did not give it to me.
And what medication do you normally take?
¿Qué medicamento estabas
Estoy tomando medicamento para el tiroides.
I'm taking medication for my thyroid,
por colesterol
cholesterol,
y para un dolor que tengo en mi espalda y en mi brazo.
and for a pain that I have on my back and on my upper arm,
Y para mi corazón.
and for my heart.
So none of those medications will affect your ability to understand this proceeding?
Ninguno de esos medicamentos afectarían que entiendas lo que estás haciendo en este proceso.
No, no.
No.
How old are you and how far have you gone in school?
¿Cuántos años tienes y hasta qué grado de escuela llegaste?
Llegué hasta 6 6 grado y tengo 53 años.
I made it until the 6th grade and I am 53 years.
Are you able to read, write, and understand the English language?
¿Puedes leer, puedes escribir, puedes entender el idioma inglés?
No.
No.
Do you understand that an interpreter has been provided to assist you if you do not understand what I'm explaining to you?
¿Ha entendido usted que está aquí presente un intérprete para asistirla a usted a entender lo que se está diciendo en otro idioma? ¿Entiende usted que es así?
Sí.
Yes.
Do you understand that you have been charged with the offense of trafficking in methamphetamine?
¿Entiende usted que la acusaron de traficar en metanfetaminas?
Sí.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to this charge?
¿Entiende usted que a estos cargos que levantaron contra usted tenía usted el derecho de declararse culpable a ellos, como lo está haciendo, o mantenerse con la declaración de no culpable? ¿Entiende usted eso?
Sí.
Yes.
And if you pled not guilty or remained silent, you would receive a jury trial.
Si hubiese permanecido como no culpable o nunca hubiese hablado o dicho nada, hubiese tenido entonces usted un juicio ante un jurado por esto. ¿Entiende usted eso?
Sí.
Yes.
Have you had enough time to speak with your attorney, Mr. Bennett, about all of the facts and circumstances known to you regarding the charge in this indictment?
¿Ha tenido usted tiempo suficiente para hablar con su abogado sobre las circunstancias, sobre los hechos conocidos por usted que formaron esta acusación que presentaron contra usted?
Sí.
Yes.
Have you discussed any potential defenses?
¿Discutieron sobre sus posibles defensas al respecto?
Sí.
Yes.
Do you need any more time to discuss the case with your attorney?
¿Necesitaría usted más tiempo o tiempo adicional para conversar con su abogado sobre esto?
No, ya es suficiente.
No, it's sufficient.
Ya.
Are you satisfied with his services?
¿Está usted satisfecha con sus servicios?
Sí.
Yes.
Mr. Bennett, do you waive formal reading of the indictment?
Yes. Si renuncia a la lectura formal del documento acusatorio, él renuncia a que se lea.
Do you also waive any and all defects in the indictment, including any with respect to Ms. Gonzalez's name?
Yes, sir. Si hay defectos con respecto a cómo deletreamos el nombre de la señora González, él dice igualmente sí, renuncia.
Ms. Gonzalez, do you recall having been arrested on these charges?
Pero González, él le pregunta, ¿recuerda usted haber sido arrestada por estos cargos?
Sí.
Yes.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Mr. Bennett, do you know of any outstanding warrants related to these charges?
No, I do not.
Pregunta a tu abogado si él sabe si hay alguna boleta de arresto que no se haya cerrado. Y él dice, no, no lo sé.
Ms. Gonzalez, has your attorney advised you the minimum and maximum sentence for each charge that you are pleading to?
Señora Robles González, ¿le ha informado su abogado con respecto a la pena máxima, la pena mínima que usted estaría enfrentando por estos cargos?
Sí.
Yes.
And Your Honor, and I believe Mr. Bennett may be able to help here.
Puede ayudarme aquí,
For the tier 1 offense,
este tipo de
minimum
nivel.
is 10 years.
Ella está
And I
enfrentando
believe the
10
maximum
años.
may be 30,
Creo
is
que el
that correct?
máximo
It
era
is.
30 y él dice, sí, ese
That's
sería
my
30.
understanding anyway.
Dice, entiendo que el mínimo por este tipo de cargo
Should be
es
16, 13, 31.
All right, I'll look it up. You can keep going.
Yes, sir.
Oh, I'm meaning Mr. Jordan can, but I'll make sure we're clear on it. So, and as I understand it, this is being negotiated to a tier 1 weight.
Correct.
Okay.
28 to 199 grams would be
De
the
28 a 199
appropriate
gramos.
amount
Es
to
lo
be
que
reflected
han
in the
llevado y es lo
Okay.
que
documents of
refleja a
conviction.
la
Got it.
final tu admisión de culpa en el documento de
And
admisión.
as
de
Your Honor
culpa.
can see, it was charged as 400 or more grams.
Esto
in
fue
the
inicialmente
indictment.
acusado como un caso de más de 400 gramos.
Ms. Gonzalez, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence?
Dice, señora Robles, ¿entiende usted que esta es una sentencia que ha sido negociada entre su abogado y nosotros, la fiscalía, en la cual yo como fiscal voy a recomendar al juez la siguiente sentencia?
And the state's recommendation, Your Honor, is that this be treated as a tier 1 offense, with the state's recommendation
Y se
being 10
recomienda
years to
que se
serve.
reduzca a un nivel, al nivel 1,
Okay,
y la pena sea la de 10 años. Y pues dice, ok,
Was that the negotiated recommendation that was communicated to you, Ms. Gonzalez?
señora González, eso fue lo que entendió que su abogado le comunicó a usted con respecto a lo que negoció conmigo.
Sí,
Yes.
Do you understand the court does not have to accept that recommendation?
¿Entiende usted que el juez no está obligado a aceptar esa recomendación?
sí,
Yes.
Do you understand that the court can sentence you to the maximum on this charge?
¿Entiendes que puede el juez, si rechaza, sentenciarte hasta el máximo que le permite la ley hacerlo?
sí,
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Debes entender que esta convicción o esta admisión de culpa puede ser utilizada en el futuro en tu contra, en tribunales federales, en cualquier otra jurisdicción, por, si entra al sistema por algo similar o por lo mismo, para incrementar cualquier pena que fuese usted a recibir por esa conducta.
sí.
Yes,
Lo sé.
I do know.
Are you currently on probation or parole?
¿Se encuentra usted actualmente bajo sentencia y está sirviendo esa sentencia bajo libertad a prueba o libertad supervisada? ¿Está usted? En alguna
No
otra
entendí.
sentencia?
No.
I did not understand.
Have you been convicted previously and on probation for something else,
Dice,
another case?
Si has admitido culpa en algún otro caso previo a este
No.
y quedó esa sentencia bajo supervisión.
No.
No.
Are you a United States citizen?
¿Eres ciudadano norteamericano?
No.
No.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation?
Debes entender que si no eres ciudadano norteamericano, tu admisión de culpa, la convicción que por tu admisión de culpa recibe, va a afectar tu estatus de inmigrante en el país, lo cual significa que a la final puedes ser deportada. ¿Entiendes eso?
Sí.
Yes.
Do you understand that this is true regardless of any advice by your attorney or anyone else?
Debes entender que esto es cierto. No importa lo que hayas escuchado de tu abogado, a lo contrario.
Sí.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Debes entender que renuncias a cualquier defensa por admitir culpa, inclusive defensas de índole por problemas mentales. ¿Entiendes eso?
Sí.
Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Debes entender que si hubieses tenido un juicio, en ese juicio hubieses sido juzgada por un jurado. En ese juicio hubieses tenido el derecho a ver, a oír y a interrogar a los testigos que hubiesen traído a declarar en tu contra. En ese juicio también hubieses tenido el derecho a no incriminarte, a no declarar en tu contra. ¿Entiendes eso?
Sí.
Yes.
And for this next question, would the interpreter prefer if I went question by question or listed out all of the items before you started interpreting?
Question by question, unless I have the document, Your Honor.
Do you understand that by pleading guilty, you were giving up the following rights, which I will now list
Como
off?
vas a declarar culpable, vas a renunciar entonces ahora a los siguientes derechos.
The right to a trial by jury,
El derecho a un juicio por jurado.
Sí.
Yes.
the right to remain silent and not incriminate yourself,
El derecho a permanecer en silencio, a no incriminarte por estos cargos.
Sí.
Yes.
the right to confront witnesses called to testify against you,
Renuncias al derecho que tenías de presentar testigos que hubiesen venido a declarar en tu contra.
Sí.
Yes.
the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case.
El derecho a que un abogado en ese juicio te hubiese asistido, uno contratado por tus propios medios o uno asignado por el tribunal si no hubieses tenido fondos suficientes para contratar uno privado.
Sí.
Yes.
The right to the presumption of innocence.
El derecho a que se te presuma inocente. Renuncias a ese derecho.
Sí.
Yes.
The right to testify on your own behalf and to present other evidence.
El derecho a declarar a tu favor y a introducir otras pruebas o evidencias si las hubieses tenido.
Sí.
Yes.
The right to subpoena witnesses and compel the production of evidence.
El derecho a hacer comparecer testigos por orden de un juez e igualmente presentar por orden de un juez pruebas diferentes a las que hubiesen ellos presentado. Yes.
The right to have the charges against you proved beyond a reasonable doubt.
El derecho, entonces renuncias al derecho de que los cargos que hubiesen levantado contra ti hubiesen sido probados en tu contra, más allá de toda duda razonable.
Sí.
Yes.
The right to appeal if convicted of these charges after a trial.
El derecho de apelar si después del juicio te hubiesen encontrado culpable o te hubiesen hecho convicta de estos cargos.
Sí.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
Te prometió a alguien, te forzó a alguien, te amenazó a alguien para hacer que te declarases culpable?
No.
No.
Your decision to waive these rights and enter a guilty plea because you are in fact guilty.
Es tu decisión renunciar a estos derechos, declararte culpable a estos cargos, porque de hecho eres culpable de estos cargos.
Sí.
Yes.
Ms. Gonzalez, how do you plead to the sole charge of trafficking in methamphetamine and indictment number 22 SC 184462?
Señora González, ¿cómo se declara entonces usted al único cargo que presentamos contra usted, tráfico de metanfetamina, bajo el caso 22 SC 184462?
Culpable.
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Ofrece su admisión de culpa de una manera libre, de una manera voluntaria, con pleno conocimiento, entendimiento de las consecuencias por los cargos que levantamos contra usted.
Sí.
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Debe entender que le queda un derecho relativo de apelar esta admisión de culpa que acaba de presentar. ¿Entiendes?
Sí.
Yes.
Do you understand that since this is a felony, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Debe entender entonces que como esta es una felonía a la que admitió culpa, le dan a partir de hoy hasta 4 años para presentar un procedimiento o una moción conocida como habeas corpus. Ese documento o esa petición le permite a usted oponerse al procedimiento en el que participó de manera voluntaria para admitir culpa. ¿Entiende usted eso?
Sí.
Yes.
And Mr. Bennett, have you advised to Ms. Gonzalez her deadline for filing a direct appeal?
González, si va a presentar por su propia cuenta, puede hacerlo una apelación directa.
I have not, but I can do so now.
Le
It's
dije a
30
ella,
days.
Pero él dice,
File
puedo
a notice
decirle
of
ahorita para presentar.
This is a new question you've been asking, and it catches the defense attorneys unaware. Is there any reason why you don't just tell the defendant on the record so that it doesn't matter how many times, 0 or 100, defense counsel has told the client?
Your Honor, I actually, from being a judge in this courtroom, the public defenders told me that they preferred that we asked if they had advised the
Si los
deadline.
abogados
So
le
that's
han
just a habit that I
informado
picked up.
Okay.
a sus clientes.
I don't want to reprogram you since you're leaving, but don't hand that script word for word over to Mr. Peoples because I will reprogram him.
Understood, yeah.
Okay, we can just tell folks what the situation is.
Entonces, es un corto periodo de tiempo. Tu abogado te dijo, son
Trying to think of
30
what
días.
possible reason there could be.
Y él dice, bueno,
Well, I mean, he explained it, is that the public defenders wanted it to be their dialogue with their client in that courtroom, and that's great. We're just not in that
es
courtroom.
un diálogo
Right.
que ha comenzado los abogados de oficio a tener con sus clientes en la sala de corte donde admiten culpa antes de hacer admisión de culpa.
And Your Honor, for a factual basis
que
on
la
this
base
case,
de este caso, lo que pasó
on August 3rd of 2021,
2021,
GBI Gang Task Force
de la unidad
and
contra
an
gangs
APD officer
especiales de Atlanta
convened
se reunieron
to basically do a drug bust.
básicamente.
One of the
arrestaron
GBI
a
agents
una
had been
persona
working
por droga.
undercover.
Hay un agente del FBI que estaba
He had been in
encubierto
contact with Miss Rosa
en
Gonzalez
contacto con la señora Rosa
for a scheduled buy.
para una compra de droga organizada.
When Miss Gonzalez did
La señora Beltrán González
go to 2685
fue al
Metropolitan Parkway,
Metropolitan Parkway.
officers were already
Los
there
oficiales
waiting
ya
to
estaban
arrest her.
allí listos cuando llegó para arrestarla con la droga.
She did give consent to
Ella
search her
dice
vehicle
que les dio permiso
after
para revisar el
officers
vehículo
read
después que
her
los
Miranda
oficiales le
rights
leyeron
in
los
Spanish.
derechos de Miranda para cuando la arrestaron.
Inside the
Dentro
vehicle,
del
there
vehículo
was
encontraron
5 suspected
aproximadamente 5
kilos of
kilos de
methamphetamine.
metanfetaminas que sospechaban ellos era metanfetamina.
There was also, I believe,
Bien
a
creen
ledger in the
que
car as well,
encontraron como un libro
with
de
names and
control
numbers
con
written on it.
nombres, números de teléfono, cantidades que dicen ellos que estaban en el carro.
From
Sí.
conversations with
De las
Mr.
conversaciones
Bennett,
que he
Your
tenido
Honor,
con el señor Bennett,
I don't believe that,
creo que
if anything, I do believe that Ms. Gonzalez
la
was
señora
a
González
middleman, for lack of better terms.
estaba actuando como intermediaria.
She may
entre-
not have been in a
quizás no
position
estuvo ella en una
to cooperate
posición
with law
para
enforcement
cooperar con los
as far
oficiales
as
del
giving
orden
up
público con respecto
her
a dar
competitors or
quienes eran
anyone that could
otras
lead to a
personas
larger bust.
que les hubiera permitido a ellos continuar la investigación para
But
hacer
we do
mayores
believe that
arrestos.
this is the best negotiated
Y dice, nosotros
resolution.
creemos que es la mejor manera de
I do
solucionar
believe
con el
that
problema
Ms.
porque
Gonzalez
que
has
ella
been told not to return to the country
creo
before.
también que la señora había
So we
sido
believe that a
deportada
straight
previamente.
prison
Creo que
sentence would be the
esta
best
sentencia
outcome, Your Honor.
simple como la estamos.
Do you think the evidence would be if this not only went to suppression hearing, but went to trial, is that Ms. Gonzalez was something more than simply the delivery person? In other words, the undercover agent placed his or her order with Ms. Gonzalez, not with unknown Hispanic male X. And then that person said, a blue Acura will show up. And lo and behold, Ms. Gonzalez is driving the blue Acura, and law enforcement knew nothing of her, but she is the transport. She's got the 5 kilos in her car, so she's on the hook for the 5. It's actually a step up from that. It sounds like, based on your review of the file.
Yes, Your Honor, that's at least from my review. I spoke with GBI agent McPhee and also GBI agent Mr. Moore, who I believe is with another county now. And that was their understanding.
Okay.
They attempted to get information from her, but.
Well, and that wasn't my point. And we don't need to get into that here. It was more that their testimony would be that Ms. Gonzalez was more than a mere knowing or unwitting delivery person, but actually took orders from customers, meaning you could place an order, I want X, with her.
I believe that's what their testimony would have been.
Okay, thank you. Let me see who we've still got on our Zoom. Ms. Roberts, good, it's still morning. Good morning. Thanks for being with us. How are you?
Good, how are you?
Do you have any criminal history for Ms. Gonzalez?
Yes, she has 2 cycles out of Texas and then 12 cycles with it's federal. She has a conviction for illegal entry in 2017.
país en el 2017.
She has another conviction for illegal entry or attempted illegal entry in 2015.
Un accidente en un carro donde alguien
2015 conviction for re-entry after deportation conviction.
una convicción por haber regresado ilegalmente al país después de haber sido deportado.
A 2014 conviction for re-entry of removed aliens.
Por haber regresado a los Estados Unidos después que te deportaron.
And then 2010 alien inadmissibility under section 212.
Caso también de inmigración.
The cycles out of Texas were not convictions, just cycles.
No eran convicciones.
That is correct. They don't appear to be convictions. That was for, the charge just says federal offense. There's no disposition listed.
Okay, and nothing from Georgia.
No hay nada.
Just this cycle out of Georgia.
Got it. All right, thank you so much.
You're welcome.
Gracias por esto.
Mr. Bennett.
Your Honor, I may have alluded to this in our previous hearing, but Ms. Gonzalez immigrated to the United States illegally after her hometown was destroyed by a hurricane in Jalisco State. She lived on an island, small indigenous community. Most of her family made the long and arduous trek across the border in order to work and support whoever was left and unable to travel. She's been deported before. Sometimes it occurred at the border. I don't believe it ever occurred far from the border. It was mostly, migratory federal crimes that she's been accused of. This is the first serious federal or felony offense she's been accused and convicted of. As for the facts of this case specifically, my reading of the file is slightly different from counsel's. Of course, I alluded to that in my motion to suppress. I do agree that there were conversations between the agent and Ms. Gonzalez. I believe the only conversation took place immediately before the delivery. I believe, on information and belief, based on my reading of the file, which is often leaving certain critical pieces out, understandably, that the broker was an individual who was present at the scene of the deal, but got away. And that Ms. Gonzalez, she's not denying that she had knowledge. She's not denying that she intended to transport the drugs and had constructive or actual possession. She's here to accept responsibility for that. She was recruited into a drug trafficking conspiracy for pennies on the dollar. And unfortunately, in a lot of these cases, this is what we see is where the lowest level person ends up scooped up and serving prison time while the people that are responsible for distributing drugs and making the money are out.
Well, we don't know what came of the larger GBI investigation and if it was the tip of a federal tentacle, but I don't disagree with anything you described. And I was pressing Mr. Jordan more so because I was intrigued that Ms. Gonzalez might have been more aware of what was going on than simply I'm driving a vehicle. I'm supposed to move away from the vehicle while some things happen. I'm going along with the recommendation. It just meant she was a little more plugged in, and that is sometimes not how it goes. Anything else you want to add?
No, Your Honor, just thank you for following the recommendation. Just want to ensure that, for parole purposes, the conviction documents do reflect a stipulated weight of 28 to 199 grams, which is tier 1. I've had the parole board misinterpret sentences before that I've had to come back and fix. Sometimes they treat it as a downward deviation, which would require her to serve the entire 10 years, which is not the intent of this plea bargain by any means. So just that's the only other thing I would add is that's as long as that's clear on the face of the indictment or the sentence or the documents of conviction, we should be Ms. Rosa should get the benefit of her bargain here.
Okay.
Y es para que usted, la señora Rosa, pueda, Beltrán pueda seguir.
Ms. Gonzalez, is there anything you want to tell me?
Señora González, ¿hay algo que quisiera usted decirle al juez?
Nada.
Nothing.
Que sea su voluntad.
Just that your will be done.
Okay. I have to ask you a few questions. Are you okay with me asking you a few questions?
Muy bien, dice el juez, ok. Tengo que hacerle algunas preguntas. ¿Está usted bien con que yo le haga las preguntas? Yes.
Okay. They're easy questions. You described a bunch of medicine you take for some of your medical conditions. You got none of that medicine while you were in jail, or you just didn't get it recently?
Usted nos comentó cuando empezamos a hacer este procedimiento de sentencia que estaba usando algunas medicinas. De esas medicinas que usted estaba utilizando, ¿esas medicinas en la cárcel se las dieron o no se las dieron?
Sí me las dan, pero hoy no me las dieron.
They provide those,
Sí me las
yes,
dan.
but today they did not give them to me.
Okay. The fact that you got no medicine today, has that made it hard for you to understand what we've been talking about?
El hecho de que hoy no le dieron esos medicamentos complicó eso, que usted no hubiese entendido lo que estamos haciendo con usted y usted con nosotros aquí.
No.
No.
Está todo bien.
Everything is
Estoy
fine.
consciente.
I am conscious.
Okay, you are conscious, but you're also understanding.
Está usted consciente y también
Sí.
está entendiendo, ¿no?
Sí, sí estoy
Yes.
entendiendo.
Yes, I am understanding.
Great. Ms. Gonzalez, do you understand that this guilty plea will result in you being removed from the United States?
Señora González, ¿entiende usted que esta su admisión de culpa, el efecto, el resultado final de ello va a ser que termine usted siendo removida o deportada de los Estados Unidos?
Sí.
Yes.
And understanding that, you still want to go forward with the plea?
Entendiendo usted eso, ¿desea entonces que continuemos con este procedimiento de
Sí.
sentencia negociada? Yes, yes.
Okay. It is a fair plea. It is shaving 15 years off the sentence you might otherwise have to serve.
Es una sentencia bastante justa, es una sentencia que está reduciendo 15 años de la pena que usted hubiese tenido que servir por esto. Yes.
Ms. Gonzalez, for me to process this guilty plea, I need you, if you're willing, to give me the authority to sign the indictment on your behalf. May I do that?
Para yo poder procesar entonces esta su admisión de culpa en la documentación de este caso, tengo yo que firmar por usted ese documento. ¿Me da permiso para firmar por usted su nombre en ese documento?
Sí.
Yes.
Mr. Bennett?
Yes, sir.
And Mr. Jordan?
Y al fiscal.
Okay.
Da igual.
Ms. Gonzalez, I find there is a factual basis for your plea, meaning I think the state could prove this charge.
Encuentro entonces, señora González, que hay base legal en base a hechos que el gobierno hubiese podido demostrar su culpabilidad por estos cargos. ¿Entiende eso?
Sí.
Yes.
I also find that your plea is knowing and voluntary. Voluntary means no one is forcing you to enter this plea. It's not a happy moment, but it is a decision that you've made to plead guilty. Is that correct?
Entiendo igualmente que usted está ofreciendo su admisión de culpa de una manera voluntaria, con conocimiento de causa. La manera voluntaria de su participación es que nadie a usted la ha forzado a hacer esto por usted. ¿Es una interpretación de mi parte correcta de lo que está haciendo?
Está bien. Sí,
That's
está
fine,
bien.
yes.
Okay. And it's also a knowing plea, meaning you've understood all the things we talked about. Is that also correct?
Y es correcto que asuma yo como la admisión de culpa, él ha dicho, es con entendimiento y conocimiento de su parte, es que usted está entendiendo lo que hicimos con usted y lo que estamos haciendo.
Sí.
Yes.
All right. Ms. Gonzalez, I am sentencing you on the only count of the indictment pursuant to OCGA 16-13-31E1. That's tier 1. Which means that I find there's a factual basis that the methamphetamine that you delivered was somewhere between 28 and 199 grams.
El juez dice, estoy sentenciándolo entonces a usted en base al estatuto del estado de Georgia 16-13-31E1, que lleva entonces su peso al nivel 1 de peso, indicando yo que entiendo que hay una base legal para hacerlo, en el sentido de que queda usted sentenciada por esa metanfetamina en el nivel 1, que significa en peso de 21 gramos a 199 gramos. Okay, thank you.
I'm going to sentence you to 10 years, and I have to impose a $200,000 fine. Those are both the mandatory minimums in this case.
La sentencio a 10 años. Igualmente, la sentencio a pagar una multa de $200,000, porque es parte de la sentencia mandatoria que en este caso exige la ley. Okay.
You will get credit for all the time that you have served, which is 630 days. So that's already part of your 10 years.
Le vamos a dar crédito por todo el tiempo que ha estado usted sirviendo. El juez ve que tiene 630 días esperando. Ese tiempo se descuenta de la sentencia que ya recibió. Okay.
And you will be eligible for parole.
y queda usted sujeta a salir bajo supervisión una vez así lo decida la Junta que conmuta las penas.
But you will likely be removed from the United States before you would be able to serve any parole.
Pero el juez cree que es posible que a usted la deporten antes de que a usted le den salida supervisada la Junta que conmuta penas.
Do you have any questions about any of that?
¿Tiene alguna pregunta, alguna duda con respecto a lo que le acabo de decir?
No.
No.
Mr. Jordan, anything else for the state? Mr. Bennett?
No, Your Honor.
All right, thank you for your work on behalf of Ms. Gonzalez.
Thank you. It would have been an interesting motion to suppress, but we would have just ended up arguing about probable cause, which rarely goes.
Well, and then you run into what does the state offer afterwards? So,
Thank you, Judge.
you're welcome. Appreciate your time.
That's it for me.
Dios los bendiga, diles.
Dios bless
Dios los bendiga.
you, Honor, and everybody.
Thank you. May you be blessed as well.
Muchas gracias. Sea usted bendecida también.
Yeah.
Okay. Bennett?
Yes, does she need to speak?
I don't know.
Yeah.
Let's look at something's matters.
Sure. You got some time for us.
So I want to make sure you guys get a lunch break. You want to knock out a few of these and then add the rest to the afternoon calendar? Okay. Why don't we do, I assume you're going to be here in the afternoon because of Ms. Wood's situation. Okay. Didn't mean to keep you here. So let's just work from the start of the calendar and then we'll break a little afternoon. We'll see how long these take. So let's bring, do you already know that some of these are going to be pleas or you know they're not pleas? We know they're not pleas. All right, let's bring Mr. Askew out, please. Is Mr. Askew on tomorrow for a bond hearing?
Yes.
All right. Does he know he's coming back? I guess tomorrow is virtual, but he knows we'll be reconnected. Okay. Thank you, Mr. Laris. And that resignation is like official?
It happened already.
All right, that's what I thought. I just, it had been such a roller coaster.
We are interviewing two. One of them is an ex-federal public defender, term 35-40-30, so she's coming in tomorrow.
All right. Well, good luck with that. Thank you. Okay, let's go on the record, please, with position 1 on our status conference calendar, 22 SC 183736, State versus Mr. Askew. Did I pronounce that correctly?
So.
Hey, Mr. Askew, you are charged with aggravated assault by way of strangulation involving Ms. Freeman from way back in September of 2020. Today, I'm just going to make sure your lawyer has all the discovery and see what's next for the case. Ms. Feely, do you feel like you've got the discovery in the case?
I believe so. We're a little too far apart offer wise, so this is not going to be a plea today. However, I expect to continue working on that. And he is set for the June trial calendar. I don't anticipate there being any reason not to be ready by then.
Okay. Ms. Willingham, any discovery you foresee, any last minute experts you'll be disclosing? I'll make sure the microphone is. Okay, we're going to hear from Ms. Rivers.
We are.
All right. Yeah.
Judge, in my review of the file, it looks like we are missing medical records. I requested those. They typically don't take long. So I anticipate we'll still have them in enough time.
Okay.
So long as they're not extensive medical records, then I don't think it should delay us any further.
Okay. And that's not something subject to suppression. That's going to either shore up your case or shore up a defense. And you'll get those to Ms. Feely as soon as you get
I
them.
get them. Yes, Your Honor.
Okay. All right. I don't think that changes anything from the way you described it. So right now, Mr. Askew's not interested in a non-negotiated plea.
That's correct.
All right. So Mr. Askew, let me tell you what that means for today. Today, you could enter a plea. Ms. Feely would argue for whatever sentence you all have talked about. I'll make one up. Probation. In other words, get out right after you plead guilty. Ms. Willingham, it sounds like, will be arguing for some prison time. If we were to do that today, and I were to sentence you to more than what Ms. Feely asked for, you could withdraw your plea. You could say, you know what, that sentence is not what Ms. Feely asked for, so no, thank you. I'd rather go to trial. Let's fast forward a couple months. It's June, it's trial time, and you realize, you know what, there's some video footage or the photos from the doctor. I don't want to go to trial. I want to enter a plea. I want you to argue for probation again, Ms. Feely. So Ms. Feely stands up and says, Judge, you should give Mr. Askew probation. Ms. Willingham says, should be 2 years to serve. And I come down sort of in the middle and say, you know what, I'm sentencing you to 14 months to serve. And I've explained why and this and that. That's a sentence you could not walk away from. Today you could, but after today, I will always welcome a guilty plea, but you don't get a back out of it if you don't like the sentence you get. Does that make sense?
Yes.
Okay, great. I just want to make sure you understood that. It may well be that this case resolves by way of a plea. It may be something that the two sides agree on. Just the difference after today is if you enter a plea, you're doing it knowing that you may not withdraw it if I give you a sentence that you don't like. I'm not telling you this because I always hand down 100-year sentences. Ms. Feely can tell you, we've been working together for several years. She can tell you Judge McBurney is going to listen to all the facts and circumstances, and she's not going to be able to read my mind, but she's going to know it's not going to be way over here. It's not going to be way over here. It's going to be somewhere right around there. So do you have any questions about anything I described?
No.
Okay, then I think I'm going to see you tomorrow virtually for a bond hearing. And I'm sorry they didn't overlap, but we don't have time today to also do a bond hearing. Plus, the state has a right to have Ms. Freeman be heard, whether she appears virtually or someone reads something on her behalf. So that's going to be tomorrow. You'll be out at the jail in a Zoom booth, but we will do that bond hearing.
Can I ask my voice?
You sure can. So I will see you tomorrow for the bond hearing. Regardless of what happens with that, I'll also see you in June because you'll be on the trial calendar. And maybe you guys are able to work something out or at least get close enough that you do a non-negotiated plea. Otherwise, let's do the trial. Okay? I'll see you soon.
Okay.
All right, why don't we do Mr. Reed and then we'll break for lunch because I need to give everyone on this call a lunch break as well.
Is Ms. Wood's case, and it actually is ready for a plea, but I don't know if it might be too complicated to try to do that with her out. I'm happy to stand in, but.
Okay.
Non-negotiated, so I wonder if that's why she's. But
Let's ask Mr. Reed, and if he says he'd like to do it today, we won't do it right now, but we'll do it today. And that's great. If he's not comfortable doing it without Ms. Wood, we'll preserve his final plea right because he was ready to go today. And we'll just get him as soon as we can, either in court or virtually, once Ms. Wood is in a position to reconnect with him.
And Judge, there is still a outstanding motion to revoke his bond on this. Obviously, we anticipate this is going to be a non-negotiated plea.
To revoke this guy who's in custody's bond.
Correct. It was for, he has two cases.
Okay.
So the bond revocation was actually for the new case. However, if we're doing a global resolution, I don't know that it's much needed, as well as on the new case, he also has no, he's in no bond status. And I believe that's why we did not move forward with it last time.
Right.
Because it was in no bond status, but I did just want to make the court aware of that. And I told Ms. Nelson I would get her something. So I will get her something in writing during this lunch break.
Got it. Mr. Reed, I'm Judge McBurney. How you doing?
I'm all right. How you doing?
I'm all right. Mr. Reed, your lawyer, Ms. Wood, is not able to be here today. Her colleague, Ms. Feely, is here. And what Ms. Feely shared with me was that Ms. Wood and you've been talking and that you were actually prepared today to enter what we call a non-negotiated plea in your two cases where you want to work the cases out, but the prosecutor, Ms. Willingham, is going to be recommending X, some number that is greater than Y, the number Ms. Wood would be arguing for on your behalf. We can still do that today if you want, but it would be with Ms. Feely. And so I want you to tell me what you're more comfortable doing. The state will keep its offer open. Whatever they were going to recommend, they will recommend. Today, if we took your plea, you'd have the ability to withdraw it if I sentenced you to more than what Ms. Wood was going to be asking for. And I'll protect that right. In other words, if you say, you know what, I'd really rather have Ms. Wood here, then we'll figure out, is it going to be next week or the week after when we get everyone back together? You'd still be able to withdraw your plea if I give you a sentence more than what Ms. Wood advocated for. But Ms. Feely is a very capable advocate. She can do what Ms. Wood was going to do. And so it's really up to you. If you're like, you know what, let's do this thing today, or I'd rather have Ms. Wood here. Your call 100%. I want to be clear. It doesn't mean, all right, I'll see you in August. It will be, I'll see you in a couple of weeks. Ms. Wood will be back next week. I have some civil cases I got to deal with next week. So either late next week or early the week after or soon around then, we could get you either on a Zoom from the jail or get you on one of the transports here. So if you want to talk with Ms. Feely about it, you can do that. I'm not putting on any pressure. You guys want to talk about it? So why don't we do this then? You talk. We're going to start our lunch break. And if it is going to be a plea, we'll do that first thing when we reconvene at 1. And then we'll press through the remainder of our morning calendar and our afternoon calendar. That will allow Ms. Rivers a chance to get a break. I trust we'll get someone from pretrial back at 1 o'clock.
I'm here, Judge.
Great. No, I see you, but I just want to make sure you can be on a lunch break till 1 o'clock. And we'll just get the update from Ms. Feely on behalf of Mr. Reed then. Okay. Hearing no objections. Deputy Gordon's objecting. What?
I don't know what calendar
Is he on the second calendar?
I'm not sure.
Oh, yes. Mr. Kuntz, you have some of Mr. Kuntz's cases? Oh, all of them except one. I think Mr. Johnson is on as a private attorney. It's not a conflict thing. Miss Deputy Gordon says he's not feeling well. Will you chat with him after you're done talking with Mr. Reed? Because you may be able to speak on his behalf at the status conference. Okay, so we're gonna break for lunch. Please be back at 1, and we'll pick up with Reed and hear what's going on with Kuntz. Thank you.
I never can get.
Well, yeah, I'm good with it.
All right, Ms. Rivers, can you hear us?
Yes, I can.
Fantastic. We are live for part 2 of today's calendar. But for those of you who are on for this afternoon's calendar, we're a little delayed from this morning. We had some transportation issues, and we need to get through the morning items first. Ms. Feely, your understanding is that Mr. Reed is going to be a plea?
I'm going to need to make a little more FaceTime with him, but I think we can do it. If
Okay.
we're on today.
Okay. Should we bring Mr. Bateman out? That's position 7 on.
It'll just be, it's not a plea. so-
That's fine, but I mean, you're ready for Mr. Bateman. Before we bring Mr. Bateman out, which we can't do because here comes the deputy. What happened with Ms. Benton? Ms. Rockwell was lurking around at lunch.
Your Honor, I just spoke with Mr. Rockwell. What I am doing right now, it seems like we may be close to a plea. I don't know if it's going to be a global resolution just right now, but the family, Ms. Benton's family, wanted to see the surveillance footage. I have that queued up for them, so whenever I get a break, I'll just allow them to watch it on my laptop.
This is not Mr. Chestnut's family, but Ms. Benton's family wants to see it. Okay. Well, you're very gracious to make the discovery available to the defendant's family. Okay, we'll circle back to that. So let's bring, if you're able to support it. Nope, no support yet.
I'm not, but.
Okay, I'm all for it too. Mr. Bateman. Good afternoon, Mr. Bateman. If you take a seat next to Ms. Feely, please. And Ms. Feely, if you could make sure the microphone is on there. And Ms. Willingham, your microphone is on?
Now it is.
Now it is. Great. Okay. This is position 7 on our status calendar from this morning. 22 SC 185167, State versus Myron Bateman. Mr. Bateman is here, seated next to his lawyer, Ms. Feely, and Ms. Willingham is here. Mr. Bateman, I'm going to hear from Ms. Feely about whether you've got all the discovery. When I say you, your lawyer has all the discovery in the case. If there are any issues I need to know about that, if this is a case that's working out today, because if it's not, I need to cover a couple rights of yours that will expire today. And then we'll make sure your case gets on a trial calendar so that it keeps moving forward. Ms. Feely, do you feel like you have all the discovery?
I do. I'm pulled it up just to double check. I think this looks like, I don't know what else there would be. So I think yes.
Okay, you're not aware of anything that's missing.
Right.
All right. Ms. Willingham, anything? Hold on.
Oh, okay.
I'm going to mute Ms. Bumpus. All right. Anything you think is heading the defense's way?
No, Your Honor.
All right. Ms. Feely, should I get the state's offer on the record so that Mr. Bateman and I can talk about that, or you're pretty clear he knows what the offer is and it's not something that intrigues him right now?
It's not something that intrigues him. However, I feel like we are moving in the right direction. So if we were to work this out, we would request a plea date.
Okay. Mr. Bateman, you are free to enter a plea at any point. You could enter a plea in the middle of your trial if that's when you decided, the better route for me, meaning you, is to enter a plea. But you, of course, have a right to have a jury hear the allegations in this case to see what the jury would do. If you were to enter a plea today, it sounds like the state would be advocating for a sentence that you think is a little too high. Ms. Feely would argue for whatever you and she have been talking about, and I'd impose a sentence. Today, if the sentence I imposed was greater than the sentence Ms. Feely asked for, you could withdraw your plea. You say, you know what? I was willing to forego trial if I could get X, but you gave me X plus 1, whatever it is. So no, thank you, Judge. All right, we unwind all that and still get you to trial. Tomorrow, although I won't see you tomorrow, next month, whenever it is, in your case, will probably be on our June trial calendar. So anytime between tomorrow and June, you could say, no, I do want a plea. There's a better offer or something's changed and I want to enter a plea, and you're free to do that. The one thing that'll change is that you will not have that ability to say, Judge, I just don't like the sentence you gave me, and so I'm backing out of it. Do you understand what changes after today?
Yes, sir.
Okay. As long as you understand that, I'm going to move your case to a trial calendar. Doesn't mean you'll go to trial. You can. It's protecting that right. But it sounds like Ms. Feely is feeling optimistic that sooner rather than later, there may be the two sides are close enough that you say, let's do this plea. Is that your understanding?
Yes, sir.
Okay. I will see you on that earlier date if that's what works out. Otherwise, at the latest, I'll see you in June for your trial.
So you saying I can take a plea now?
No, I didn't say you have to do anything. You don't have to do anything at all.
Yes, sir.
What I was saying was that if you were to enter a plea right now, the state would recommend
Your Honor.
nothing.
Oh, no. The state's offer was 18 serve 8. Ms. Feely did come back to me with a counter of 10 serve 5. I would honor that 10 serve 5.
Okay. So meaning that's something that you would recommend today? Or when you say, I'm not sure what you mean by honor, you're free to argue for whatever. I just need to tell Mr. Bateman what it is. If I say we're going forward with the plea, Ms. Willingham, what is the state's recommendation?
Yes, Judge, the state's recommendation is the 18 serve 8. I just wanted to be clear. So, because I know Ms. Feely and I had the discussion about the counter, so I didn't want it to seem like I was pulling back on
Got
that
it.
if he did that today.
No, I understand. Meaning if Ms. Feely advocated for that, you wouldn't say, wait a minute, there's.
Correct.
Okay, got it. So, Mr. Bateman, if you were to enter a plea today, the state would recommend 18 years to serve 8 with a balance on probation. So 8 in custody, credit for time you've been in, followed by 10 years on probation. That's what the state would recommend. That doesn't bind me. I could give you more. I could give you less. And I would certainly listen to Ms. Feely, who it sounds like would be arguing for less. What I was saying about today is that if I give you a sentence that is more than what Ms. Feely asked for, today you could say, you know what, Judge, my lawyer argued for this number. You gave me more. I'm going to go to trial. I think I got a better chance to avoid the number you gave me by going to trial. And I'd say, okay, you can do that. If you enter a plea next week or at the end of May, your lawyer can still argue for whatever you two talk about. But if I give you a sentence that is more than what Ms. Feely asks for on your behalf, you can say, I don't like that sentence, but you don't get to withdraw your plea. That's the only thing that changes. Does that make sense?
Yes, sir.
Okay. So what I heard you say is not interested in the state's recommendation and that you would like your case to go on the trial calendar, which doesn't mean you can't plea. It just means right now you are a little far away from the state's recommendation and you would prefer that we keep your case heading towards trial. Is that correct?
Yes, sir.
Okay. Then I will see you either when Ms. Feely and you have worked something better out with the state or, like I said, for your trial. Okay?
Yes, sir.
Thank you.
Okay.
Is Mr. Williams here? He was in Cobb. Great. Is there a different way I should explain it, or we just didn't click on that?
I think we just, and I will start now that we know that these are final plea calendars, explaining all that ahead of time. So
Okay, then we're fixing it. Very soon, these calendars will say final plea.
Yeah, because that's certainly a conversation I can have with them.
Okay.
ahead of time.
Ms. Willingham, yes, you have both of Mr. Williams' cases.
Yes,
They're one indictment apart,
they are.
one number apart. Okay. Good afternoon, Mr. Williams.
Good afternoon.
How are you?
Doing fine.
Good. So before we get on the record with your case, I'm curious, and you don't have to answer if you don't want to. Back in the day, folks were kind of okay with being housed in Cobb because the situation was a little better than being down at Rice Street. Is that still the case, or is it bad news being up in Cobb?
I mean, it's not bad news because Wright Street, they ain't doing nothing but stabbing over there. So Cobb County is a good jail.
Okay, I mean, I understand jail in general is bad news, but you're okay still being in Cobb.
Yes.
Okay, good to know. Let's go on the record. Mr. Williams has two cases on our calendar, 22 SC 185335 and 22 SC 185336. Ms. Feely is his lawyer for both. She is seated by his side. Ms. Willingham is the prosecutor on both. You're charged with family violence, battery, felony in both cases with a few other charges. Ms. Feely, do you have, as best you can tell, all the discovery in the two cases?
I believe so, yes.
Do the two cases involve the same alleged victim?
Yes, Your Honor.
Okay. Ms. Willingham, anything else likely coming from the state other than you may identify an expert on the cycle of violence or something, but not
No, nothing.
crime lab info?
Correct, Your Honor.
Okay, so it seems like the cases are ready for trial. Ms. Feely, are these cases that are resolving today, or there's distance between the two sides?
We're closer than on some of the cases, Your Honor, but we're not quite ready to, I'd like some more time to negotiate.
Okay. Mr. Williams, I just need to make sure you understand one thing about that. More time is fine. Your cases will move to a trial calendar now. That doesn't mean you can't resolve them with a plea. You could do that at any point, even in the middle of trial. Today was the last day to enter a plea where you would have the right to back out of the plea if I gave you a sentence higher than the sentence your lawyer asked for. So I'm gonna make up some numbers. You decide, you know what, I want to plead guilty to these cases. Ms. Willingham says, Mr. Williams should serve 3 years. And Ms. Feely says, nah, he should serve 1 year. If I were to sentence you to 1.5 years, that's more than 1 year. And so you and Ms. Feely could talk about it, think, what are we going to do? Nah, no, thank you, Judge. I was willing to do 1 year. I want to back out of this. State needs to prove its case at trial. Today, you could do that. After today, you can still enter a plea to both your cases, and it probably would be what we call a global resolution. But if we have that same scenario, state asks for 3, your lawyer asks for 1, and I say, I think it's going to be 1.5 years, you wouldn't be able to say, no, thank you. You could still tell me, I don't like that sentence, but you could not back out of the plea. You understand that?
Mm-hmm.
Yes?
Yes.
Okay, understanding that, Mr. Williams, are you all right with me moving your case to the trial calendar? You may still work this out, you're just not working it out today.
Yes.
Okay, that's what we'll do. I will see you at the latest in June for this trial calendar. Before then, if you and Ms. Feely get closer with the state as to how this might work out. If you get something close like that, Ms. Feely can either get you virtually or in person with pretty short notice.
Can I ask a question right quick?
Sure.
Even if I go back to trial, could they at least put me on probation for 2 to 3 years?
So the state's going to recommend whatever they recommend. My guess is it will include some probation, but right now it sounds like it includes some jail time as well. They don't decide what happens. They recommend an option. And then Ms. Feely will give me her thoughts and your thoughts about what should happen. And then I make a decision. You understand that?
Mm-hmm.
Okay. So we will see you. My guess is it sounds like before the trial calendar, because you all may have worked something out, and we'll talk then.
Yeah.
So I don't see Ms. Benton. Oh, you're going to show some video. So we'll hold off on that. We did Ms. McBurrows, who has a lawyer now. Mr. Brown didn't show up. Ms. Craig is coming back. That's the calendar. All right. Let's do our afternoon calendar. And let's make sure we've got who's online as well. How about Brian Marshall? Ms. Bumpus, I know you are here.
Yes, Judge.
How are you?
I'm doing good. Sorry, I didn't have my thing muted. Sometimes when you come in, it comes in unmuted.
That's not a problem.
I spoke to him earlier. He should be on. I gave him all the information.
All right. Well, why don't you reach out to him and we'll go through the calendar one more time and maybe he'll show up. But don't disappear because you've got position 2 as well. Willie Lewis.
Yes.
Oh, Willie Lewis is here. We're going to bring him out. Okay.
Okay.
And I will spotlight you. There you are. And
Oh, yeah, that's gonna work here.
Caleb, Bumpus.
all right. Let's go on the record with position 2 for this afternoon's status conference calendar. It is State versus Willie Lewis. Mr. Lewis is here in person. Ms. Bumpus is appearing virtually as she moves from courthouse to courthouse on this busy day. Ms. Willingham is the prosecutor. Ms. Bumpus, do you have, oh, Mr. Lewis has 3 cases, all handled by Ms. Bumpus. So we'll talk about all 3. Ms. Willingham, do you have all 3 or just positions 2 and 4?
I have all 3, Your Honor.
Okay, well, that'll make things simple. Ms. Bumpus, do you have the discovery in all 3 cases?
Yes, Judge.
Okay, any issues you see from your review of the discovery?
No, Judge.
All right, Ms. Willingham, any discovery heading Ms. Bumpus's way?
No, Your Honor.
Okay, she's got it all. Ms. Bumpus, is there any reason we should not move Mr. Lewis's 3 cases to the trial calendar? Is this something that's working out today, or you and the state are far apart?
We are very close, very, very close. The issue is, and I honestly, we pre-tried it, and I really appreciate ADA Willingham. She's been very, very, very communicative, and we pre-tried it yesterday. I don't know what to do. Her recommendation, not to speak for her, is for him to do RSAT.
Okay.
I do think it's a good idea. My only concern is that my client has already been in custody for over a year, and then I don't know how long it'll take him to go, and then do another 9 months. I just don't think that's reasonable. So I'm in the process of trying to see what kind of wraparound service we can provide him without him just staying in custody, because he's been in custody for over a year.
Okay. Well, you guys are free to keep talking. I don't know any of the facts and circumstances. I will note, and they're only allegations, but Mr. Lewis has 3 different cases that seem to allege that he assaulted someone with a deadly weapon. So I'm not necessarily feeling real troubled that the state would be recommending that Mr. Lewis be in jail longer. But I don't know anything about the 3 cases. So that's something that Ms. Bumpus, you and Ms. Willingham can keep talking about. What the plan is to move these 3 cases to our June. Is this on the June trial calendar? I can look. You don't have to.
But we are trying to work towards getting something done sooner than that, Judge. And that was just my whole point of putting that on the record.
Okay, no, I appreciate that. These cases will be all 3 on the June trial calendar. So that's not all that long from now. So one way or the other, we will get a resolution, maybe one that's you all agree on it. It may be one where it's a non-negotiated plea and I'll sort it out, or the state could take one of the 3 cases to trial and we'll see what happens. Anything else, Ms. Willingham, that we need to cover?
Nothing further, Your Honor.
Mr. Lewis, do you have any questions about anything we discussed?
Is there a way that I could retain my paperwork, my arraignment, or excuse me, my indictment paperwork today? Like I had it sent to it was supposed to be sent to me, but it ended up getting sent to my residence.
Okay.
So I mean, I've been trying to get. I have yet to know anything with regard to.
When you say your indictment paperwork, if I can get you copies of your 3 indictments, is that what you mean?
Yes. Anything that basically anything that basically tells me about my case that I can read and look at it and you know, that's kind of been the major issue with on my end, being in custody for over a year and not even being able to sit here and say, you know, anything that is factual with you know, in black and white.
So
just to let you know, I'm going to visit him today.
okay, great. Now he's up in Cobb, so I don't know when he'll be back in Cobb. I mean, he'll go back today.
Around 7, Judge, because to give him time to get back.
Okay, got it. Hold on one second. Yes, ma'am.
I'm his older sister.
Okay.
Here with my mom here today. And so if there's any way that I could be of assistance in getting the paperwork, whatever it is to him, I'm able to do that as well.
Okay, so Ms. Bumpus, you may not have been able to hear that, but Mr. Lewis's older sister is here. She used that description. I would say sister. She said older sister is here and is offering to serve as an intermediary in terms of routing paperwork. But if you're going to see Mr. Lewis this evening, you will be able to share with him far more than I could get him. All I can do is print out indictments, and those are bare allegations. There are no police reports or anything, but Ms. Bumpus would have all of that. So
I'm saying if my older sister has the paperwork that was sent to the house, may I have that?
do you have the paperwork with you now?
I do not.
Okay, so no. I noticed you've got an envelope in front of you. Does it not have paperwork in it?
What is in here is basically my log of me journaling my mental health as far as people I've spoken with and getting keeping record of my medication and things like that. Journaling my medication and when they give it to me and all that, just keeping track of it for my own records, as well as I can, shows consistency with the development of my mental health issues and all that. And it also includes a short synopsis of my mental health background, basically, give to my attorney, which, you know what I mean?
Well, what I can let you know is that I just looked at 2 of the indictments and they allege that you committed an assault on Ms. Gray. One was March of last year and the other was November of 21. And there's one more case, it didn't pop up. So I'm going to let Ms. Bumpus cover all that with you, but I don't want this to be a bolt from the blue for you. Okay.
Right. And that's all I really wanted. I'm used to things working a little differently when it comes to this sort of procedures. I'm used to, having, like I said, just paperwork that I could look at. So that's the only thing that's really been my issue with.
Got it. Well, sounds like Ms. Bumpus is going to address that today when she swings by up there in Cobb County. And if she needs the assistance of your sister to get more to you, she'll do that. Okay.
Okay. Thank you so much.
You bet. Ms. Bumpus, we'll move the 3 cases to the June trial calendar.
Thank you. And I just want to let the court know, Judge, I am proud of my client. He has been doing really good with his mental health and staying, getting healthy. So he has while in custody, and that's really, really hard.
No, it is. So if you're getting medication, make sure you keep taking it, Mr. Lewis. That's definitely something that's going to keep you in the right lane.
Yes, sir.
All right.
Thank you so much.
You bet. I noticed that Mr. Marshall has joined the call. So let's get him on the screen.
Good afternoon, Judge.
Whoops, that's not the right one. Hey, good afternoon. Give me 1 second. There he is. Okay. So let's do the status conference for Mr. Marshall. It's position 122 SC 182627. Ms. Bumpus, also your case. but I think that's it. You'll be able to go after this. Do you have the discovery in Mr. Marshall's case?
Yes, Judge.
Okay. Who's handling this for the state?
This is my case, Your Honor.
Really?
Yes.
All right. Because of the unit you're going into, or it's just yours anyway?
No, Your Honor, I believe that the first two counts were added on. They may have been added on after a preliminary hearing. I've talked to the victim to get more information about them, but apparently those are trial line offenses nonetheless.
Okay, great. Ms. Bumpus says she's got discovery. Anything from the state side?
Your Honor, I haven't been able to convey an offer to Ms. Bumpus just yet. I have been in constant talks with my supervisor in regards to this case, and full disclosure with the court that the charges, at least when I first received the case, seemed to be all over the place. I was able to speak with the listed victim, Ms. Dominique Jones, and she did give me a little bit more information on where the charges come from. I'm working, Ms. Bumpus, as hard as I can to try to get a new offer to you. I do have one that I can convey if Your Honor would like right now on the record.
No, why don't we do this? You and Ms. Bumpus should continue to communicate, and I appreciate you working hard on this. I will move this case to the June trial calendar, but I will preserve Mr. Marshall's final plea rights because it sounds like things are evolving. And it's not because Ms. Bumpus has been out of the country or something like that. But you're getting your arms around what is a peculiar set of allegations.
Yes,
so what all that means, Mr. Marshall, is at the latest, I'm going to see you in June because your case is going on the June trial calendar. Ideally, before then, the prosecutor and your lawyer will talk more, and maybe there is some kind of resolution that the two sides can agree on, and they would bring that to me and we'd go forward with that. But if you remain too far apart in your respective notions of how this case should be resolved, then we know at the latest we'll see in June for a trial. Okay?
Judge, can I say something?
Yes, you can.
I would like to request that this be specially set for the first available trial date because I'm very disheartened at the way that this case has been handled. This is a 2000 and I don't even know. It's 3 years old almost.
2020. No, the conduct is, oh, that's the wrong indictment. I want to speak out of hand. Well, it doesn't matter. It is, I'll take you at your word that it's very, very old conduct. The next available trial calendar is my June one. The May calendar has already been published. So the next calendar to be published is the June trial calendar. It's the very beginning of June. So it's like 5 weeks away. And Mr. Marshall will be on that calendar.
Okay, thank you, Judge. I just want to let you know that we are ready. We can be first out. I'm ready to handle this.
Okay, I can't guarantee you first out. There may be people who've been in jail for a real long time. My point is it'll be on the trial calendar, and based on what you've been telling me, I ought to prioritize it. So it'll be on there. Maybe before then, you all will sort something out. Mr. Jordan, anything else?
Nothing further from the state, Judge.
Okay, all right. Thank you, everyone. Mr. Marshall, you are free to go.
And Your Honor, that concludes my business. May I be excused?
You may. Please swing by Cobb and say hi to Mr. Lewis.
I will. Thank you, Judge.
All right, bye-bye. All right, Brian Newcomb. He should be in custody.
He is in custody. I saw him last week. He has been found incompetent to stand trial.
Oh.
I don't know that we need to bring him out.
We don't. Is that something I've received too?
I'm not sure. It happened pre-indictment.
Oh, huh. And he got indicted anyway.
Yeah.
Look at that. So he was indicted in July of last year. I think it was done before it got transferred to us. No. Not. Hold on. Okay, I signed an order in February, consistent with what you said, but that was after indictment. So either way, we can't move forward with this. Do you know, I guess he's either going to be in the restoration pod or he's in that long line.
Yes, and there is actually somebody in here for him that I'm going to speak with as soon as there's a break, but I saw him last weekend.
Okay, well, if you talk with family about that, we'll move this to an inquiry calendar a ways out.
Thank you.
Thanks. Baron Carter.
Good afternoon, Judge. Richard Blevins for Mr. Carter. He's online as well.
There he is. Mr. Carter, can you hear me? Who's handling this for the state?
That's my case, Your Honor.
Okay.
I'm not sure why it says Ms. Williams on the calendar, but we do have I believe that we have a negotiated plea in that case, Your Honor.
For today?
Yes, Your Honor.
Okay, well, we can do that. Let me get through. We don't have much left on the calendar. We'll do that, Mr. Blevins, since we've got you here in just a moment, but Mr. Carter's going to need to come off mute. So maybe you could work with him to see if he can figure out how to come off mute if we're going to take the plea. Is that your understanding of what we're doing as well?
Yes, sir. We have a negotiated plea. And I think it required some days in custody. I just need to talk to Mr. Jordan, but I didn't know if we could come in live for that. I didn't know how the court want to handle that.
I'm happy to provide a reporting date. That's how I'd like to do it, is take the plea and then just have a reporting date. So unless there's a reason you don't want to do, you and Mr. Carter don't want to do that today, we ought to try to knock it out today.
All right, I'll speak with him about the mute and that as well, Judge.
Great. I'll circle back to you all. If you want to shoot a text or something in the chat here that he's sorted out his mute, that'd be great.
Yes, sir. Thank you.
Thank you. Okay, Mr. Kuntz is next. He's got 4 positions, and Ms. Feely stepped. Right, but she's just not here. So we'll need her because she's got all the remaining. Hey there.
Sorry.
No, that's okay. You were talking with folks. I just noticed the rest of the positions are probably yours. So Mr. Kuntz, I know you're waiving his presence. Are we good with discovery as to your 3 cases?
Yes.
Okay. What's your understanding, having spoken with the different prosecutors, as to which case would go?
My sense is Mr. Shapiro's case.
Okay. Mr. Jordan nods vigorously. Okay. What's your sense about how that would play out? Meaning, I call it for trial, Mr. Kuntz comes out and sits with you, or we need to get on the record, maybe in a quieter setting, that he is waiving his immediate presence. He'd be around because I'd want you to be updating him so that if at any point he changes his mind, it's not a call to the sheriff to get to Rice Street, but it would simply be, hey, you can come right on out at any point.
I am still working in the hopes that he would be able to be present for a trial.
Okay. But he understands, as best you can tell, that if that's the one the state wants to go forward with, that's what would go first. And he would be able to elect on the record, it could be a very small group talking about it, to be back in lockup instead of in person. Okay, all right, then let's move these. They'll be on the June calendar. And Mr. Jordan, if you could just alert Mr. Shapiro that you've nominated his case to go first. Hopefully that's not a surprise for him.
I believe he's in the know, Your Honor, and I think that he may be in the process of trying to craft a new global offer. I'm not sure if he's been able to communicate it to Ms. Feely yet.
Okay. Ms. Nelson asked a good question, and that's the case ending in 740. I know that Mr. Kuntz at one point had been able to afford Mr. Johnson. Would you mind reaching out to Mr. Johnson to see if that's something where he might withdraw because he hadn't been paid to do more than whatever he did? If you get no response, let me know, because then I'll reach out, copying you and Mr. Jordan on that one. But it would be best for Mr. Kuntz if the resolution covers all four of his cases, rather than that one lingering around. Okay. You'll let Mr. Kuntz know what we talked about. All right. In the case ending in 399, if you could enter an appearance or do a substitution of counsel, it's your colleague, but it shows up as Ms. Gowdy, if I'm pronouncing that correctly. And it would be great if it says you. I appreciate the one that'll likely go, already has your name on it, the case ending in 362, but let's try to have them all linked that way. All right. All right, next up is Giovanni Walker.
Mr. Walker is here.
Hey, Mr. Walker, come on up and sit with Ms. Feely, please. All right, let's go on the record. This is 22 SC 183897, State versus Giovanni Walker. Mr. Walker is represented by Ms. Feely, who is here. State is represented by Ms. Willingham, also here. Mr. Walker, you're charged with aggravated assault and family violence battery in this case. Do you have the discovery in the case, Ms. Feely?
Yes, and I believe this one is one that we are close enough that I would, if I can speak with Mr. Walker a little bit more and Ms. Willingham, I think we could work out today.
Okay, so Mr. Walker, it may be that you enter a plea today. The benefit of entering a plea today is that you can withdraw that plea if the sentence I impose is more than you ask for. So in case it's non-negotiated, state says 1 year, your lawyer says 6 months, and I say 10 months, 10 is more than 6. You will have the ability to talk with Ms. Feely about it and say, I don't want to do that. And you get a walk away from it. After today, I'm happy to take a plea. There's just no walking away. Whatever sentence I impose will be what you get. Understand?
Yes, sir.
Great. So we're going to press through the rest of this calendar. I have a plea I can be taking that doesn't involve Ms. Feely, and you and she can talk a little bit more. Okay? So sit tight.
All right.
But back there.
All right.
Thanks. Ronald Richardson is in custody. I'm going to give Deputy Gordon a minute. How about Mr. Huff is not here. Scotty Wyatt. We're ready for Ronald Richardson or Scotty Wyatt, although I heard someone fussing at you.
Yeah, so I gotta work with my assistants.
Oh, that's what the fussing was? Okay. Dang. Is assistance coming?
Hopefully.
Hopefully. Dang, they don't bring the inmates, then they don't give the deputies.
Almost there.
Tough day. All right, why don't we do the plea? It sounds like Mr. Carter was able to get us some audio there. Mr. Carter, can you hear me?
Yes, sir. Can you hear me?
Yes, I can. So let's get everyone on. There's Mr. Blevins. There's Mr. Carter. Okay, we'll work through that. Let's go forward. Are you, Mr. Jordan, you ready?
Yes, Your Honor. And Mr. Blevins, I apologize before we go on the record. I know we had negotiated to the fleeing, eluding, and reckless driving. The state, given what the statute says, would feel more comfortable only proceeding on the reckless driving. Is that okay with you and your client?
Yes.
Just wanted.
Wise move not to object to further
No
dismissal.
objection here. You
Okay.
understand, Mr. Carter?
Yes, sir. I understand.
We're just going forward on the reckless driving.
Oh, man, that'll work. Thank
He's an over to the road truck driver, Judge, so that helps his CDL out. So we
Okay, well, if you just wait a few more minutes, they may drop more counts.
Yeah. Can we go on?
Well, if you do that, that would certainly help.
All right, but it's not going to happen. So let's go forward.
I understand.
So, Mr. Carter, we're going to go on the record in your case now. 22 SC 183287. Mr. Carter, you are appearing. Is that the cab of your truck?
Yes, sir.
Okay, you are free to do that, but you need to tell me on the record that you are okay with the fact that you're not here in court. You all right with that?
Yes, sir. I'm not in court.
You are not in court. That's correct, and that's okay.
That's okay with however my lawyer proceeds it.
Okay, well, it's really actually your right to waive, so you need to tell me you're waiving your right to be here in court and you're okay proceeding from the cab of your truck.
Yes, sir.
Okay, the other right that you are waiving before we even get started is to have Mr. Blevins right by your side. He is virtually by your side. He is in the cab of his home office. And that's where he is appearing from. Are you all right with the fact that he's not right next to you?
Yes, sir.
Okay. If at any point you need to speak privately with Mr. Blevins, let me know, and I'll put the two of you in a breakout room where you can speak and no one else will be able to hear what you're talking about. Okay?
Yes, sir. Yeah, that's well understood. Mr. Blevins, we already took care of it.
Good. Well, if something comes up and you need to take care of it again, tell me when you're ready, Mr. Jordan.
Thank you. Mr. Carter, can you please raise your right hand?
Yes, sir. Can you see it on the camera?
Yes, sir. Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Baron Carter.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, you can't drive in the truck. Can't drink and drive.
That doesn't mean you didn't do it, though, so you need to tell us the answer.
No, sir. No, sir.
Okay.
Is there a medication that you normally take that you have not been given today?
No, sir.
How old are you and how far have you gone in school?
I finished school 12th grade and I am 56 years old.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with the offense of reckless driving?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney, Mr. Blevins, about all the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your attorney?
No, sir.
Are you satisfied with his services?
Yes, sir.
Mr. Blevins, do you waive formal reading of the indictment?
We do.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Carter's name?
I do.
Mr. Carter, do you recall having been arrested on these charges?
Yes, sir.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Mr. Blevins, do you know of any outstanding warrants that are related to these charges?
I do not.
Mr. Carter, has your attorney advised to you the minimum and maximum sentence for the charge that you are pleading to?
Yes, sir.
And Your Honor, just for the record, reckless driving has a minimum of 1 day in custody and a maximum of 12 months in custody. Mr. Carter, do you understand that this is a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Your Honor, the state will move to dismiss all remaining counts. I believe there are 7 counts on this indictment. Let me make sure. 6 counts, my apologies, Your Honor. The state will move to dismiss counts 1, 2, and 3, and 5 and 6 in exchange for a plea to count 4, reckless driving. The state's recommendation as to the reckless driving is 12 months to serve 10 days. The balance being probated, that Mr. Carter consumed no alcohol or drugs, and that he be subject to random testing. Your Honor, all other counts will be dismissed in exchange for a plea to count 4. Was that the recommendation that was communicated to you, Mr. Carter?
Yes, sir.
Do you understand that the court does not have to accept that sentence?
I don't know about that part, but no, I don't understand that one.
Mr. Carter, the judge, even though we have a negotiated plea and an agreement between ourselves and the prosecutor, the judge he can elect not to take the plea. If he does, you can withdraw your plea and have a trial on the issues, okay?
Okay, I understand that. Yes, I do.
Yeah, and so we're extra clear on this, Mr. Carter. If I disagree with what you all negotiated and I go higher than that, you'll be able to withdraw your plea if you and Mr. Blevins think that's the right step. So just as an example, if I say, nah, I think Mr. Carter needs to do 6 months in jail, you would be able to say, whoa, I'd rather go to trial. You may say, I don't like that, but I'll take it. But you'll get a chance to withdraw your plea if I exceed in any way what was negotiated, okay?
Yes, sir.
Do you understand, Mr. Carter, that the court can sentence you to the maximum on this charge?
Yes, sir.
Are you currently on probation or parole?
No, sir.
Do you understand that if you are placed on probation as a result of pleading to this case, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
May I say something real quick? Mr. Carter, if you could sit still and have your face on the camera, please.
Yes, sir. Yes, sir. Yes, sir. Just
We're
moving
doing
around.
a plea as if we're in court, okay?
Yes, sir. Sorry, but apologize for that. Thank you.
That's okay. I'm not quite sure what we're seeing. There we go. Well, still can't quite see you. There. All right. Thank you, Mr. Blevins.
Mr. Carter, are you a United States citizen?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
Mr. Carter, how do you plead to the sole charge of reckless driving in indictment number 22 SC 183287?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes, sir.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, sir.
Do you understand that you only have 12 months from today for this misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And do you understand you only have 30 days from today to file a direct appeal?
Yes, sir.
Your Honor, for a factual basis on this case, on June 16th of 2019, an officer from the Atlanta Police Department was shooting a stationary laser on I-20 westbound when an officer did see a vehicle traveling at a high rate of speed. The officer stated that the vehicle was going 105 miles per hour in a 55 mile per hour zone. The officer stated that he got the vehicle speeding on his laser. The officer told dispatch that the vehicle was a gray Mercury Marquis and it was getting on I-20 westbound coming back towards the city. They did have to get an air unit involved and able to locate the vehicle. The officers were eventually able to pull over the vehicle and then engage the defendant, Mr. Baron Carter. Mr. Carter was irate when the officers pulled the vehicle over. Then officers did note that he had bloodshot, watery eyes. Mr. Carter did refuse a chemical breath test and at that time had been arrested under suspicion of DUI and also felony fleeing and eluding. Your Honor, that concludes the factual basis for this case. Your Honor, I believe that looking through this police report and reviewing the body camera that was sent to Attorney Blevins, I do understand that it's very, very dangerous to go 105 miles per hour, especially within the city limits. I believe that the DUI investigation may not have been done properly, but given the age of this case, and I don't believe Mr. Carter has a particularly long history, we would ask that you accept this negotiated plea. We also did reach out to the officers involved. I believe that one of the officers is no longer with APD, but I did speak to one of the officers. He remembered the incident, but he was not opposed to the reduction.
What about the incident was so memorable that almost 4 years later, he was remembering it?
I think they remembered the helicopters specifically, Your Honor, that were involved in the brief chase. So I think that's what allowed them to remember the incident.
Okay. Ms. Smith-Mann, thank you for joining us. What can you tell me about Mr. Carter's criminal history?
Yes, Your Honor. Since the last 10 years, there is a 8/2015 willful obstruction of law enforcement officers. That's time expired. There's terroristic threats and acts, time expired. 6/2019 DUI, driving under the influence of alcohol, Your Honor, time expired. 2/2020 failure to appear. Second count, failure to appear for simple assault. First account, obstruction of officers. All time expired on them, Your Honor. There is a total of 9 cycles, not including the one that is before you today, Your Honor. Nothing further.
Thank you. When you say time expired, what does that mean?
What that tells us is the jurisdiction has not inputted a disposition for that into GCIC or the FBI agent.
Got it. So it could be that there was a resolution to the 2015 obstruction case, but no one followed through by entering in that disposition. Right. I shouldn't assume there was a disposition. It just means you don't have additional information beyond the fact that he was arrested in 2015 for obstruction.
Correct. According to GBIC and NCIC, nothing from the agency has been entered.
Got it. Thank you so much.
You're very welcome.
All right, Mr. Blevins, tell me why our trucker should get this outcome for driving 105, fortunately not in a big rig.
Yes, Judge. He's not your typical person you would see that would have these types of charges. Usually we would see younger individuals. He's 56. I do concur with Mr. Jordan about the DUI investigation. There's not a lot to it. But the speed was there. That's why he's pleading to the reckless driving. It will be a serious violation on his CDL, which can, if he gets collection of those, I think 2 in a certain period, that will suspend him. He has taken that in consideration. There is some age on the case as well, Judge, and we just ask you to accept the plea as negotiated. He is trying to work and support his family as a truck driver. As you can tell, he's in his truck, and that's all I have at this time, Judge.
Got it. Mr. Carter, anything you want to add?
The only thing that I want to add that, for the reckless driving, I apologize to the public, and I guarantee you, this will never happen again.
Why are you guaranteeing that? What's changed in your life?
Well, for one reason, I made almost $200,000 last year, and on my way to buying a house, just in a simple truck. And 4 years ago, when I got in that incident, that just really went through. And like I said, it finally got in my head saying that, look, you doing pretty good. So,
right, you are. That's a lot of money to earn. Trucking is lucrative right now, so you don't want to jeopardize that by other foolishness.
Yeah, that really was. But other than that, I'm ready to get the ball rolling on this. I'm gonna put this behind me, and like I said, again, I apologize to the city of Atlanta, to the courts and everybody, who was involved, and even to the police. I apologize for being involved. And like I said, I just want to put this behind me, go for it, continue making money. Hopefully, I can get a house, but by this setback, it's going to set me back just a little bit. But once I get through again, then I can proceed to try to buy a house.
All right. Well, I hope you're able to accomplish that. Mr. Carter, if you were here in court, I would have you physically sign your indictment indicating your guilty plea to count 4, reckless driving. Do you authorize my staff to sign the indictment for you?
Yes, sir. As long as my lawyer is there to witness that, I'm good.
Well, so I'm going to ask him the same question. He will not be there to witness it. I'm going to ask if we can sign his name as well. That's how we do these things virtually. You say on the record, this is all being taken down. Judge, it's okay if you assign Baron Carter's name. Mr. Blevins, is it okay if we sign your name?
It is, Your Honor.
And Mr. Jordan?
Yes, Your Honor.
All right. So we're going to sign all those names. You okay with that, Mr. Carter?
Yes, sir.
All right. Mr. Carter, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. Voluntary means no one's threatened you to enter this plea. You've decided it's the right way forward for you. Is that correct?
Yes, sir.
And a knowing plea just means you've understood all the things we've talked about. Do you have any questions about anything we've discussed?
No, sir.
Then I'll accept your plea. I will follow the recommendation. And on count 4, reckless driving, I'm sentencing you to 12 months to serve 10 days in custody with the balance on probation. Your lawyer has asked that you be allowed to turn yourself in on May 9th, which is a few Tuesdays from now, May 9th. You would need to be here in my courtroom, which is courtroom 8D as in Delta, by 9 a.m. on May 9th.
Yes,
if you
sir,
are
I'll be there.
okay, if you are, the sentence that I'm going to sign says 12 months to serve 10 days. If you don't show up that morning and Mr. Blevins isn't calling saying, no, he's going to be here, his truck broke down, if there's not a legitimate excuse for you being late, I'm going to sign a different sentence. And what it says is 12 months to serve 3 months with a balance on probation. So you can buy yourself 90 days in jail if you don't show up on May 9th. Okay?
Yes, sir. Yes, sir. I'll be home.
Excellent. If something comes up, you just start blowing up Mr. Blevins's phone so he can let us know that there is an issue.
Yes, sir.
The one special condition of your probation is that you will be subject to at least 2 random drug and alcohol screens a month while you are on probation.
That's cool.
Mr. Jordan, anything else in Mr. Carter's case?
Your Honor, this was originally a state court matter and it was transferred to Superior Court, and also in complete candor with the court, I originally negotiated a plea to the fleeing and eluding and also the reckless driving. Upon reading the statute, I wanted to make sure it wasn't an illegal sentence, because I do believe the statute says that the felony fleeing and eluding is not to be reduced to a misdemeanor. So I felt more comfortable moving forward with just the plea to the reckless driving.
Got it. Meaning you had negotiated a misdemeanor outcome.
Yes, Your
And
Honor.
the reason why count one went away is that it wasn't clear to you that legally you could make it a misdemeanor.
Yes, Your Honor.
Okay. I get it. I also appreciate Mr. Blevins's observation that in a month and a half, this case will be 4 years old. And I did not hear pretrial services report all sorts of arrests since this. There was one FTA that sounds like it was a little bit of a wild hair, and that's it. So that's what we're going to do, Mr. Carter. You need to make sure you come to courtroom 8D as in Delta. Don't park your truck outside the courthouse, because you're going to be gone for 10 days. Don't show up with lots of luggage. You just show up with real basic clothes on May 9th, okay?
Yes, sir.
All right, Mr. Blevins, anything else?
No, Your Honor, that's all I have.
All right. Excellent. You two are free to go.
All right, thank you, Your Honor.
All right, thank you.
All right. Get him out of there. Can we have another person now? Thank you for being here. Excellent. Can we bring Mr. Richardson out?
Your Honor, if I may step out so I can show the.
Yeah, that'd be great. Ms. Rockwell's been very patient. So you're going to fly without a laptop, or is Mr. Richardson's case Ms. Willingham's?
This is my case, Your Honor, that it should be a brief announcement.
Okay. Well, let's get it on the record. Just need to get the case up. There it is. Okay. Let's go on the record with position 12, State versus Ronald Richardson. Good afternoon, Mr. Richardson.
Good afternoon, Mr. McBurney.
How are you?
Judge McBurney. I'm doing okay.
All things considered. Mr. Richardson, you're here in court with your lawyer, Ms. Feely. Mr. Jordan, the prosecutor, is seated at the table across from you or to your side. Ms. Feely, do you have all the discovery in the case as best you can tell?
I believe so, yes.
All right. Mr. Jordan, any outstanding discovery issues you're aware of?
No, Your Honor.
Any reason we can't move Mr. Richardson's case to a trial calendar?
No, Your Honor.
Was that your brief announcement?
Yes, Your Honor.
All right. Ms. Feely, we're far apart on this one?
Yes.
Okay. So, Mr. Richardson, we're going to move your case to a trial calendar. In fact, it's already on the May trial calendar. So you'll be back here. Is that not, people are looking, am I correct? It's on the May trial calendar?
I believe.
I'm pretty sure it is. It says here on Odyssey, it better be.
It's one of the later positions, but I do believe it's on there.
Okay, good. Well, it sounds like you're ready to go.
Is there any way that you can?
So, Mr. Richardson, I will see you in a couple weeks when we call the May trial calendar, and we'll figure out where in the list you go. You, give me 1 second. You've been in for a while, so your case will be higher up the list. You've been in for almost a year now, at least, but that's what it's showing for this booking number. It also says you've got some warrants, but either way, we will see if we can get your case either resolved or tried on this May trial calendar. Any reason that wouldn't work for you, Ms. Feely?
I don't think so.
Okay, all right, May it is. Any questions about any of that, Mr. Richardson?
Yes, sir.
What question?
The only question, last time I came and I was telling you that I kept getting stabbed at the jail. I just got stabbed like 4 days ago and had to get stitches right here on my arm.
Okay.
I was just
so should I see if you could go to there are a couple other places where they're housing people like Cobb County.
Is there any way I'm like I have family that stay in the Gwinnett area. Is there any way that I can go there for like visitation purposes?
No, that's not in the cards right now, but why don't we do this? Why don't you and Ms. Feely talk, and you can share with her your concerns and your preferences. And if she tells me that you would like to be moved to a different jail, then I'll see if the sheriff is willing to do that. I'm not his boss, so I don't get to tell him. Okay. But often when a judge says, look, there've been some issues, we're able to say, what if we move this guy to Cobb County or Alpharetta or wherever? Sometimes the sheriff will do that.
I spoke to him. He said that the only thing they had was pretrial, that was available, Cobb and Alpharetta. So, I mean, I'm just trying to stay safe because it's been so hard to get in hold of her because like at the jail, like it's like people get out, like they popping in the rooms.
I have heard from a number of inmates how it's not a good situation.
Like
so
you can be sleeping and like 6 dudes could come in your room. Like it's no officers on the floor. You know,
it doesn't sound like it's a safe environment. So talk with Ms. Feely, and if she says to me after the two of you have spoken, let's try to get Mr. Richardson to one of those other places, then like I said, I'll make an inquiry as to whether we can have that happen. Okay?
Okay.
All right.
Do you have another way I can contact you? Because that phone number has some Can you just write it down or you give it to me? Because that girl, his father's been trying to contact with you. She said that you
didn't. No Huff yet? No. Okay. Scotty Wyatt. And that's all I've got on the calendar. Sir, you've been here the whole afternoon. Did you have a case on here?
He's for Mr. Newcomb. Position 5.
Okay, so you'll be chatting with him? Okay.
Briefly, I think he's going to talk.
Okay, all good. I just want to make sure we weren't making you wait. If you thought there was another case on here, I'm like, oh, I got to the end of the list. Okay. Hey there, Mr. Wyatt.
All right, how's it going?
All right, let me get Ms. Feely up there with you and we'll get going. Okay, this is position 14, our last status conference on here. Mr. Wyatt is present with his lawyer, Ms. Feely. It's another Ms. Willingham case, 22 SC 184938. Ms. Feely, do you believe you have all the discovery in the case?
I do, and I also believe we have a negotiated plea.
Well, all right. Ms. Willingham, are you ready to do that? Or do you feel surprised by this development?
I did make the offer, so I'm happy that it's a negotiated plea. If you just give me a second to pull up the facts and stuff, then I would be ready to.
I'll definitely do that. Why don't you two confirm that you have the same thing in mind? And while you're doing that, Mr. Shapiro, if you are here only for Mr. Kuntz.
I am, Judge, and I apologize for being late this afternoon.
Mr. Jordan covered ably for you by saying, you know what, the case we want to try, that Shapiro case is the one we'll do. Mr. Kuntz didn't come out, but he did confer with Ms. Feely. Ms. Feely has said, we're good to go on the 3 cases she has. I've asked her to reach out to Mr. Johnson to see if he might withdraw. My guess is he hasn't been paid to go to trial in the trafficking case. That way you and Ms. Feely can talk about all 4 cases. But Mr. Jordan very graciously said, if one is reached for trial, it would be your case.
I appreciate that from Mr. Jordan.
Yeah.
So, yes, Judge, state will be ready.
Good. You and Ms. Feely will want to keep talking, 1, about a global resolution, but 2, there is the possibility that Mr. Kuntz would choose to not be in court for the trial. He'd need to come out initially so I could make a record. And I share that with you because I would ask you to make sure you think the record is as thorough as it ought to be, should Mr. Kuntz decide to have the trial be in absentia. I explained to Ms. Feely, he'd actually be here the whole time so that 1, she could confer with him during any break. And 2, if he had a change of heart with a moment's notice, he's out here in court. But it may be that we have that not unheard of, but unorthodox way of moving forward.
Understood, Judge.
Okay.
Thank you.
Great.
May I have the excuse, Judge?
Yes, sir.
May I step outside as well? Yeah.
Sure.
And apologies again, Your Honor.
No, it's not a problem. I assumed you weren't going to be here and then Mr. Jordan was covering for you. You just may not want to let that happen again. Mr. Wyatt, we're just waiting. The prosecutor's pulling up all your paperwork on a screen.
Okay.
How'd you get to Cobb County?
How I got there, Fulton County.
But, well, I know, but some of the gentlemen I talked to who are in Cobb say is good. They'd rather be there than Rice Street. I was wondering,
the comparison.
Well, but I'm curious if you volunteer for it or if it's random or if you're doing well, like, hey, let's move him to Cobb. He's behaving well. We'll reward the good behavior. It's just random.
It's just random.
You wake up one morning and they say, get on the bus.
And you're on the bus.
Okay. Yes, you are.
Yeah.
Bear with me when we start. I'm just going to be flipping between a few screens, but.
Not a problem. You've done these before. All right, Ms. Rivers, are you ready?
Yes, I'm ready, Judge.
Great. Position 14, State versus Scotty Wyatt, 22 SC 184938. Mr. Wyatt is in court with his lawyer, Ms. Feely. Ms. Willingham is here for the state. Mr. Wyatt, Ms. Feely tells me you're ready to enter a plea in this case. Is that correct?
Yes.
Great. Please, if you would, if at any point during our conversation you have any question about anything, because you're confused by something or it's just not going the way you expected, will you let Ms. Feely or me know that?
Yes, I will.
Thank you. When you're ready, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name, your age, and your date of birth.
Scotty Wyatt, 12/16/1970.
And your age.
52.
Are you now under the influence of any medicine, drugs, or alcohol?
No.
How far did you go in school?
10 with a GED.
Can you read and write in the English language?
Yes.
Have you had the opportunity to review the document that charges you in this case?
Yes, I have.
Do you fully understand the nature of the charges pending against you?
Yes.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes.
Do you understand if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes.
The negotiated sentence in this case, as to count 1, aggravated assault, is 5 years to serve 1. As to count 2, aggravated assault, 5 years to serve 1. And as to count 3, battery is served 12 months. And those sentences would run concurrent, meaning all together. You would also be required to have no contact with the victim, complete family violence intervention program, and no weapons. Is this what has been discussed with you?
Yes.
Can you, I got distracted by something. Can you say the state's recommendation
Yes.
one more time,
Your
please?
Honor, as to count 1, 5 years to serve 1. As to count 2, 5 years to serve 1. As to count 3, serve 12 months. The sentence is to run concurrent. No contact with the victim, complete family violence intervention program, and no weapons.
Got it. Thank you so much. I apologize.
No problem. You're pleading guilty today to 2 counts of aggravated assault, family violence, which each have a minimum of 3 years and a maximum of 20 years, and to battery misdemeanor, which has a minimum of 1 day and a maximum of 12 months. Do you understand those minimum and maximums?
Yes.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No.
You heard me tell the court what the negotiation is in this case, which is 5 years to serve 1 year total. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 41 years? Do you understand that?
Yes.
Do you understand, however, that if the court does not accept this negotiation today, you have a right to withdraw that guilty plea, and that is for today only?
Yes.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. Under the general conditions, you will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to have no contact with the victim, complete family violence intervention program, and no weapons. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
No.
Have you understood everything I have asked you so far?
Yes.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes.
Is your decision to plead guilty made freely and voluntarily?
Yes.
Did you in fact commit the offenses to which you are pleading guilty?
Yes.
Are you a United States citizen?
Yes.
If you wish to challenge this plea for legal error, you have one of 2 ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered for the felony offenses and 12 months from the date the sentence is entered for the misdemeanor offense. Do you understand these time limits?
Yes.
Should the state proceed to trial in this matter, we would prove beyond a reasonable doubt that on March 21st, 2022, officers arrived at sorry, it is not in that part. Officers arrived at Andrew Young International Boulevard Northeast and Fort Street Northeast in Atlanta, Georgia. And it's not done. And once getting there, Officer Gaines and Sergeant Peavy were flagged down on a dispute with a weapon where a knife was used. Officer Gaines responded accordingly and was the first on scene. A male victim was bleeding from the hand, who was identified as Mr. Louis Ponce. The other male was found walking on foot, heading in the direction of Ellis Street. Unit 2508 was able to intercept the male and detain him. The male was identified as Mr. Scotty Wyatt. Officer Gaines was advised that the two Black males were involved in a physical dispute regarding an alleged stolen phone. Unit 83 stated that the two were fighting in the middle of the street, and Mr. Wyatt then began to beat Mr. Ponce with a stick. Shortly after that incident occurred, it is reported that Mr. Ponce was in possession of a knife and walked towards Mr. Wyatt. Unit 83 was on scene at that time and advised Mr. Ponce to drop the knife. He then acknowledged the officer's request and put the weapon down.
But so I'm not getting misled here, not intentionally. What you're reading right now is that Mr. Ponce had the knife.
So at the beginning of that, Your Honor, the defendant hit.
I got it. Mr. Wyatt supposedly
Yes.
hitting Mr. Ponce with a stick. And then the police show up, they hear, hey, someone's got a knife, and it's Mr. Ponce who's got the knife because,
Yes.
okay. I just want to make sure I'm following that because the indictment charges Mr. Wyatt with hitting Mr. Ponce with a stick, but it also says that he threatened him with a knife. And maybe you're going to get there.
Yes, it's in the next paragraph.
Got it. Okay. But initially, Ponce has a knife.
Yes, Your Honor.
Okay.
Mr. Ponce stated that him and the accused are in a relationship together and they live together inside a tent. Mr. Ponce was visually upset about the fight. He stated that they were having an argument when Mr. Wyatt hit him with a stick. Mr. Ponce stated that Mr. Wyatt was in the possession of the knife first and pulled it on him. Mr. Ponce stated he tried to take the knife away, but while doing so, he cut himself with it. Grady was then notified and responded to aid Mr. Ponce. Mr. Wyatt stated that Mr. Ponce stole his phone and he refused to give it back. He stated that he acted in defense of his property. Officers noted that Mr. Wyatt was the primary aggressor. Mr. Wyatt was charged accordingly without incident. He was then transported to Fulton County Jail for processing. The knife was transported to property for evidence.
Did you say in there that Mr. Wyatt explained to the police he was mad because Mr. Ponce took his phone or the other way around?
That Mr. Wyatt stated that Mr. Ponce stole his phone.
Okay, and so
refused to give it back.
according to Mr. Wyatt, the fight started because Ponce took his phone, it's words, then it's stick, maybe a knife.
Yes.
And yes, Ponce had the knife in the end, but his version of events is that's because I took it from Mr. Wyatt, and in taking it from him, that's how I cut my hand.
Yes, Your Honor.
Okay. And the police sifted through all that and said, we're going to arrest Mr. Wyatt, not Mr. Ponce.
Yes, Your Honor.
Okay. Thank you.
Nothing further from the state.
All right. Ms. Smith-Mann, tell me in the last 5 years, how many cycles Mr. Wyatt has? If that's easy for you to do, I don't mean to make it complicated.
All right, Your Honor. The last 5 years. Okay, let's see. There will be and it looks like 10 within the last 5 years.
10?
10. Yes, Your Honor.
Okay, got it. And then are you able to tell if Mr. Wyatt is on probation for anything at this point? We don't think we have, well, we've got 2 people from pretrial, we're double covered, but we don't have anyone from probation.
Yes, Your Honor, and I just have not been paying attention. Officer Roberts is actually your officer, so.
Okay, I was not ignoring Officer Roberts. She's probably loving it that I'm calling on you. I love the double coverage. We can maybe take turns for answers. But I was curious if one of you knows if Mr. Wyatt is on probation.
Now, there's no further action anticipated. It's restricted. This is 10-215 for a probation violation for battery, family violence, failure to appear for fingerprintable charges, failure to appear, and that fingerprintable charges was obstruction of law enforcement. The other failure to appear was with interference with the government property, but there are no further action anticipated, Your Honor, as of 9/2020.
Okay, all right, thank you so much. Ms. Feely, what do you want to tell me about Mr. Wyatt? And I think he's told you, we know each other. Mr. Wyatt was in drug court for a while, didn't work out, but so we have some experience, and that's why I was asking about the probation. I just want to make sure if we go forward in this way, and it seems like a reasonable outcome, there aren't probation consequences that we couldn't otherwise resolve today.
So as you heard, the facts are kind of a mess on this one, but Mr. Wyatt has been in jail since his arrest on March 21st of 2022. So he's done over a year, and he does want to avail himself of the state's offer at this time. He's 52. The court may already know he's from Atlanta, Old Fourth Ward neighborhood. He does not have any children. He was working for almost 5 years at Mary Max, and he's hopeful that he can return to that job when he is released. So we are asking the court to accept the plea as negotiated.
All right, Mr. Wyatt, anything you want to add?
No, I'm good.
You're good?
Yeah.
Okay, so Mr. Wyatt, a couple questions. One of the conditions that the state has asked me to impose is that you have no more contact with Mr. Ponce. Now, if you two are still close or you want to get close again, that's something you have to put on the brakes for 4 years. Is that realistic, or is that someone who you think you're going to be seeking out for companionship, not to go beat up, but to reconnect with when you get out?
No.
You've gone separate ways?
Right.
You'll be able to honor that condition?
Yes.
Okay. Second question is, where are you planning on going when you get out? Do you have a place to lay your head? You're going to need to go to a shelter? You have family?
My sister at 435 Harding Avenue with my sister.
Okay. And does she know you may get out soon?
Yes, I talked to her yesterday on the phone.
And she'll take you back?
Right.
Okay. Well, good. All right. I hope that works out. Well, Mr. Wyatt, I find there's a factual basis for this plea. I'm not picking sides on it. It sounds like you and Mr. Ponce got into it, and there may have been some evidence that he was doing something to you, but in the end, the police who would come testify, sounds like they would conclude that either you got the better of him, or at least you were doing more to him than he was doing to you. And so they put the charges on you. I also find that your plea is knowing and voluntary. That just means you've understood what we talked about, and no one's forcing you to enter this plea. You've decided this is the way you want to move forward. Do you agree with that?
Yes.
Okay, then I'll accept your plea. I'm sentencing you under the Probation Options Management Act. And all that means is that for the 4 years you're going to be on probation, if you have a minor violation, maybe you miss a reporting date with probation. Hold on 1 second. Goodbye, Mr. Jones. Good seeing you.
Good seeing you, Judge.
If you miss a reporting date, then something minor like that, you and probation will resolve that issue. You don't come to court for that. But if it's more serious, you get arrested again, we'll get together and talk about you're 52, you need to stop doing that, and there could be more severe consequences. Mr. Wyatt, may my staff sign the indictment indicating your guilty plea?
Yes.
All right, for you, Ms. Feely?
Yes, sir.
And Ms. Willingham?
Yes, sir.
We'll do that. That means I've covered everything. I will follow the joint recommendation. Count one, your sentence is 5 years to serve 1 year. With a balance probated, you'll get credit for every day you've been in. And by my math as well, you've been in for more than a year. So you should be released tomorrow. If it's Friday and you're still in, please call Ms. Feely, and she will help me figure out what's going on. But you should be released. Count two, 5 years to serve 1, balance probated. Count 3, 12 months to serve, They'll all run concurrently with each other. Special condition of probation number 1, no contact with Luis Ponce, none. And number 2, you will complete a family violence intervention program. Are there low-cost versions? I don't want to set up a situation where, what would you're hoping to go back to Mary Max.
Right.
If that doesn't work out because you've been gone for too long and they say, I'm sorry, Mr. Wyatt, we moved on. What else might you do?
I mean, Paul said, this is what I was thinking, what about some community service in the act of that, just in case it don't go right with Mary Mac, since I've been gone from Mary Mac for a certain period of time.
Well, I want to be clear, if you don't have a job, you're not in trouble with probation. So I might give you community service, but that's usually viewed as part of the punishment. And you're not in trouble if Mary Max isn't going to take you back. This family violence intervention program is a good thing. It's a series of classes that I think would help you, sort of like drug court. It's not about addiction, though. It's about interacting with people. It's not free. And so I want to make sure.
That's what I was talking about. The payment plan.
Yeah.
That's what I was saying about Mary Max, because once I get out, I'm gonna have to go and like my ID card, it don't expire.
Yeah. So you got some steps you need to take.
Right. And then plus the program.
Yeah. Why don't we do this? First, I'm going to waive your probation supervision fees for the first 3 months. So you're not going to have to pay probation anything. And Ms. Nelson, I hope you're writing all this down because probation didn't join us this afternoon. I know you are. And 2, you'll need to complete the family violence intervention program in the first 18 months. You don't need to start right away. You're going to figure out how you're going to earn some money. Your sister's going to want you to do that so you can help cover household expenses. But if Mary Max doesn't work out, you're going to have a while to find something. And you can find something. There are temp agencies out there that'll work with folks with your background to help you do something you can get paid for. But then you'll still need to do that family violence intervention program. Okay. Ms. Willingham, anything else in Mr. Wyatt's case? Ms. Feely?
Yeah.
All right, Mr. Wyatt, I hope this works out.
Okay.
Were we going to do something with Datavius Waller today?
Your Honor, I had received the email about that case, and I believe Your Honor previously said it would be scheduled for today, but I did subpoena an officer, but she wasn't going to be able to come today regardless.
You lucked out. I don't know that Mr. Waller's even here, but it was part of today, though he wasn't on a calendar either, but his petition for revocation was here. Do we know, if that was a Ms. Wood case, we ought to pause it anyway.
I believe so. I know right at the end of the trial, I sent the discovery link to both Ms. Feely and Ms. Wood, just to be sure, because I know the original indictment, I believe, ends in a 0, but
does.
So I'm not, I believe that may be a Ms. Wood case, but the state is ready on that probation hearing, Your Honor. It would be just one witness. We would ask for it to be an in-person hearing.
Ready, just not today because you don't have okay. I don't know that Mr. Waller's here. We'll close the loop. Let's go back to Ms. Benton. What are we doing with that? Because Ms. Rockwell is still here. Ms. Benton is still here. I got to find that calendar. Pardon me?
That would be the one.
I know. I'm just trying to find it amongst my papers here. I wonder if I turned it upside down. I did. So we've got Mr. Reed still to talk about and Ms. Benton. So let's talk about Ms. Benton.
So we would like to try to tender a plea, a non-negotiated plea with the right to withdraw, Judge.
Okay. Just to the indicted case.
Yes, sir.
All right. You ready for that, Mr. Jordan?
Yes, Your Honor. We would only proceed forward on count 1. We would move to dismiss count 2.
Okay. Before we do that, was it Mr. Reed who was maybe going to be a plea? Am I misremembering that, or?
There was talk of that is one that's Ms. Woods, so I'm not sure if we'll be able to do it today.
Okay. So should we preserve his final plea rights and then it'll move to a trial calendar naturally. And if something can happen sooner than that, Ms. Wood will reach out.
That would be great.
Okay. All right, so for Deputy Gordon's purposes, is there anyone else in custody who you still need to work with, Ms. Feely?
I think we're done.
Let me just go through one more time. I think Ms. Benton is the only one left from this morning's calendar and this afternoon's calendar. You guys are loading up that June trial calendar. Oh, Mr. Walker, who's still here.
Yes, so I believe this is, I don't know if you know this about Mr. Walker, but he travels to join us from Colorado.
Oh,
So
all right. So we should try to resolve things today.
I think we're close.
Let's invest in that. Okay. How'd you get here? Okay. Flew here. All right. And then Huff's gonna be a no-show today.
Probably.
All right. Thanks, Sheriff's Office. All right. We will reset. Was that gonna resolve today? You get to talk with Ms. Feely because this plea we're about to do, she's not involved with, so you guys can talk more. Should we just move it to a trial calendar, or there was a possibility we should give you and Mr. Huff a chance with court right here? Maybe it would resolve with a plea that he could withdraw.
I think we're kind of far apart, but I would like the opportunity to at least negotiate and try for something.
Okay, well, I assume it's already headed towards a trial calendar. Do you want it to magically somehow appear on a calendar again before then? Or what if we just preserve his final plea rights? Okay. There were no discovery issues? Okay. Excellent. All right. So we don't need to keep anyone up here. Ms. Rockwell, are you ready? If you're ready,
Yes, Judge.
then you and Ms. Benton can come to the podium. All right, so you're still here, Ms. Willingham, because Mr. Walker is your case. Got it. All right. All right, Ms. Rivers, you ready?
Yes, I'm ready, Judge.
Okay.
Did you hand me an indictment?
I don't. I will, assuming we get far enough through the process, I'll ask Ms. Benton and you if you are willing to let my staff electronically sign.
Oh, did you? Okay.
All right, let's get going. This is position 12 from this morning's status calendar, 22 SC 183599, State versus Shalacia Benton. Ms. Benton is here with her lawyer, Ms. Rockwell. Mr. Jordan represents the state. Ms. Benton, Ms. Rockwell tells me that you are interested in moving forward with a non-negotiated plea with the understanding, and it's a correct understanding, that if I sentence you to more than what Ms. Rockwell asks for, you'll have the right to withdraw your plea. It doesn't automatically get withdrawn. I will have you and Ms. Rockwell talk about it if I sentence you to more. I don't know what I'll do. I need to hear about the case and hear about you. But if I do exceed her recommendation, then I'll ask the two of you to talk about it. And then Ms. Rockwell is going to let me know what you want to do. And if you want to withdraw, it's done. It's withdrawn. You go home, and this will go on the next trial calendar, and it'll be a trial unless something changes. Okay?
Okay.
All right. So in just a moment, Mr. Jordan will put you under oath. I need you to promise me that you will let me or Ms. Rockwell know if you have any questions about anything we're discussing.
Yes.
Okay.
And
Ma'am.
just for the record, the indictment has count 1 ag assault, and she knows that the minimum maximum is 1 to 20. Count 2 is the a firearm charge, which is during the commission.
Right. I thought Mr. Jordan said that's being dismissed.
That's correct. So what I had told her was that the cases as they were, minimum maximum was 20 plus 5, because that's being dismissed. The minimum maximum is just going to be 1 to 20.
Sure. And Mr. Jordan will cover that, but assuming it's a standard aggravated assault, it's not family violence or anything like that, the range would be 1 to 20, and count 2 is dismissed. So it doesn't matter what its range was.
Yes, sir.
All right.
And Judge, we are going to be requesting first offender treatment
Okay.
under 42-8-60.
All right.
Ms. Benton, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Jalacia Benton.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there a medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
I'm 26. I went to college. Well, I'm back in there, but I graduated from college also.
Okay.
What was the first thing you said? You went to college, but?
I'm back in.
Oh, you're back in. Got it. So you got a degree and you're getting a different degree.
Yes.
Okay.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have been charged with the offense of aggravated assault?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes.
Have you had enough time to speak with your attorney, Ms. Rockwell, about all of the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
No.
Are you satisfied with her services?
Yes.
Ms. Rockwell, do you waive formal reading of the indictment?
So waived.
Do you also waive any and all defects in the indictment, including any with respect to Ms. Benton's name?
So waived for the purposes of the plea only.
Yes, my apologies. Ms. Benton, do you recall having been arrested on these charges?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Rockwell, do you know of any outstanding warrants related to these charges?
I don't know of any outstanding warrants.
Okay.
And she has been arrested on these charges.
Understood. And as previously stated, Ms. Benton, has your attorney advised to you the minimum and maximum sentence for the charge that you are pleading to?
Yes.
And as already stated, Your Honor, the minimum is 1 year and the maximum is 20 years. Ms. Benton, do you understand that if your guilty plea is a blind plea, also called a non-negotiated plea, the state may still recommend a sentence to the court?
Yes.
Are you aware of the state's most recent offer?
Yes.
And Your Honor, just for the record's purposes, the state's offer was as to count 1, 5 to serve 1, with the balance being probated. The special conditions of probation would only be that Ms. Benton have no contact with the victim, Mr. Chestnut. And also, I believe we discussed an anger management course. I believe Ms. Rockwell may ask for an evaluation. Is that correct, Ms. Rockwell?
We're making different propositions, Judge, and that will be part of my request.
Okay.
So my recommendation, Your Honor, would just be that she have no contact with the victim and also attend and complete an improved anger management course.
Okay.
Ms. Benton, do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum on this charge?
Yes,
Do you understand that if you enter a non-negotiated plea, you will still have the right to withdraw your plea once the sentence has been announced?
yes,
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
So if you're sentenced as a first offender, the way Mr. Jordan just described, that's not accurate, but he doesn't know how I'm going to handle this. I don't have to sentence you as a first offender just because you asked for it. If you're sentenced as a first offender, then it's actually not a conviction today. Let's say I accept first offender, I sentence you, you accept that sentence, you go about your business, whatever that means, you don't have a conviction, and you will continue to not have a conviction as long as you do okay as a first offender, and you can actually get it all expunged. It can blow up on you, and I'll talk about that in a minute. But if I don't sentence you as a first offender, then what Mr. Jordan said is correct, that it would show up as a conviction.
I don't want that.
Okay.
Okay, that's good to know. That would be what you could withdraw from. I don't know whether I'm going to sentence you as a first offender or not, because I haven't heard about you or your situation with Mr. Chestnut. So that would be a reason to withdraw your plea if I don't sentence you as a first offender.
Okay.
Ms. Benton, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes,
Have you ever pled guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
no, I never got in trouble.
Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act?
No,
Has your lawyer, Ms. Rockwell, explained the First Offender Act to you?
yes,
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for the charge that you are pleading to in this indictment?
yes,
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
yes,
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
yes,
Do you understand that by pleading guilty, you were giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
yes,
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
no,
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
This is more or less an offered plea, Judge. We do disagree with some of the facts, and we'll just speak towards that. It's when it's our turn.
Okay.
Ms. Benton, are you pleading guilty under North Carolina v. Alford because you have decided that it is in your best interest to do so?
yes,
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Except for the first offender part.
yes,
Ms. Benton, how do you plead to the sole charge of aggravated assault and indictment number 22 SC 183599?
guilty,
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
yes,
Do you understand that you only have a limited right to appeal this guilty plea conviction?
yes,
Do you understand that since this is a felony charge, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes,
And do you understand that you only have 30 days from today to file a direct appeal?
yes.
Your Honor, for a factual basis for this case, on May 24th of 2022, an officer from the Atlanta Police Department observed a red Kia exit the Starbucks parking lot toward the plaza exit at 330 Piedmont Road. Approximately 3 minutes later, a call was dispatched over Zone 2 radio that a Black female driving a Kia pulled a gun on a Starbucks employee located at the same address. A canvass of the area was conducted and the vehicle was observed in a nearby driveway, which was across the street from the incident location. A Black female was observed in the driver's seat. The female was detained without incident and identified as the defendant, Ms. Benton. Ms. Benton was read Miranda warning and stated that she was willing to speak without an attorney present. Ms. Benton stated that she was not intoxicated and that her highest level of education at that time was completing high school. Ms. Benton stated that she was waiting in the drive-through to Starbucks when the cashier became impatient with her. Ms. Benton stated that the employee refused to place her order due to her order taking too long. Ms. Benton stated that they exchanged words and that the cashier, also later to be found as the victim, Mr. Dwayne Chestnut. Dwayne is spelled D-E-W-A-Y-N-E, last name Chestnut, C-H-E-S-T-N-U-T, shut the drive-through door, striking her face. Ms. Benton asked if she was outside of her vehicle when this happened, and she stated that she was. It was further stated that Mr. Chestnut hit her in her face with his hand in a manner that seemed to be reflexive. Ms. Benton stated that after this happened, she obtained her firearm from her dashboard, but did not point it at anyone. Ms. Benton stated she thought about using it in response to him hitting her, but that she thought about her life and chose not to. Another officer did speak to Mr. Chestnut at the incident location. Mr. Chestnut stated that Ms. Benton had an attitude during their interaction there, so he refused to give her service at the drive-through. She replied that she was going to come up to the window and exited her vehicle. They exchanged words, and as he closed the drive-through window and told her bye several times, it was stated that he walked away from the window, so she started banging on the window several times. Mr. Chestnut walked back to the window in response to the banging and observed Ms. Benton pointing a gun at him. Mr. Chestnut obtained his coworker's cell phone and took a picture of her vehicle. He stated that's when he observed her driving off the property. Ms. Benton was asked for consent to obtain the firearm from her vehicle, and she stated that the officers could obtain the firearm. An officer did secure a Glock 26 9mm containing 1 magazine and 3 rounds of ammunition from Ms. Benton's vehicle glove compartment. At that time, Ms. Benton was arrested for the offense of aggravated assault. Your Honor, we just had the opportunity to look at the surveillance video. In the surveillance video, you do see there's no sound to it, so what you can assume is a heated exchange between the two parties. It is very difficult to see the gun. I believe that the officers may have drawn the correlation between the two accounts and understanding that a gun may have either been picked up or pointed at that point. Mr. Chestnut the state has been in constant contact with Mr. Chestnut. He's viewed several of the previous hearings on YouTube. He did want to convey that he believes that Ms. Benton should serve some time in custody for pointing the gun at him. Your Honor, given the evidence that we do have, the state believes that it would be able to show at trial that this incident did happen. We do understand that the video, at least for the weapon pointing, is because of both the position of Mr. Chestnut's back and where the window is, it's very difficult to see the gun. But we do believe that this was a serious incident. This was a public incident, unfortunately. So that's why the state is asking for 5 to serve 1. We do understand that Ms. Benton does not have a criminal history, that she does have one matter that's remained unindicted, and it seems like that case has remained unindicted for good reason. That the state understands that she is first offender eligible. And I apologize, Your Honor, I believe that I may have stated the state is not opposed to early termination of her probation after the first 3 years if there are no further violations. That concludes the state's presentation, Your Honor.
So the only witness to the gun that you're aware of is Mr. Chestnut. They're not coworkers or someone else who was in line. In theory, the surveillance camera is a witness, but you've watched the video now more than once. I'm sure Ms. Rockwell has highlighted for you its lack of clarity, but your candid assessment of the video is that reasonable-minded jurors could disagree as to whether it shows Ms. Benton with a gun.
Yes, Your Honor. There is at one point you see, because the camera is not all encompassing, it only focuses on the window, where Mr. Chestnut reaches back to get the cell phone, and you see someone handing him a cell phone. That individual could possibly be a witness, but we have never been given that person's name.
Okay, I'm talking about today. Today, you're not aware of, you're being creative, and hey, it could be we could figure out who was working that day and they would be able to corroborate in some way, but no one you're specifically aware of.
That is my understanding.
Okay, got it. All right, we're back to only one. No, we still have 2 pretrial services officers. I'll go back to Ms. Roberts for this one. Ms. Roberts, what can you tell me about Ms. Benton's criminal history?
She just has 3 cycles. There's current arrest, the open, aggravated assault, and then a theft by shoplifting, which was dismissed.
How long ago was the theft by shoplifting?
Give me 1 second to pull that back up, please. Theft by shoplifting was in 2013 with APD. It was no prize in 2000. So it looks like it was no prize May 3rd, 2022.
Okay, it sat around for a while. All right, thank you so much.
You're welcome.
Okay, Ms. Rockwell.
Judge, you have heard she is 26 years of age. She's from Atlanta, went to Westlake, graduated in 2014, then went to West Georgia where she studied criminal justice, graduated in 2019. She is the mother of an 8-year-old son who was also in the car and who talks about to everybody at school how the guy in the window threw some coffee on him and got coffee on him. Talks also about how the police officers pulled her hair and all that. It was kind of a big deal to her 8-year-old. The video does not show her pointing a gun at him. The video does show her very close to the window and him shutting the window, and she told officers there that he had hit her in the face with the window. What was very interesting about the video is that there seemed to be
So it shows that Ms. Benton actually, this was not a walk-up window, like she's walked up to the drive-through window to yell at this guy.
she's in the drive-through.
On foot.
No, her car is there, but she's in the window close enough to where, and she said to the officers that he had closed the window and struck her in the face.
So Ms. Benton does not get out of her car. She
gets out of the car. Well,
what does the video show? Does the video show Ms. Benton feet in the car or feet out of the car? That's a different level of aggression. If she's so angry about not getting coffee that she's actually gotten out of her car to accost this guy.
Your Honor, I apologize if you're asking me.
I am asking you.
Yes, Your Honor. At least from what I could see, it looked like she had stepped out of the vehicle, but not almost at not a full standing posture.
But like her door's open.
Yes, at least from what I saw, Your Honor.
Okay.
What's interesting about the video is that there was an incident that happened with Mr. Chestnut with a car in front of hers that somehow is not in the video at all. But anyway, the video does show that there was a lot between the two, Judge. You can see, like Mom says, the body language of the worker, et cetera. What I know is that he doesn't work there anymore. What I know is that she is gainfully employed also. She works for AT&T. She's got a good customer service job. She has an 8-year-old child now. The elephant in the room is that she has another case where I kind of think maybe that the 5-to-1 might have been given because of this other case. What I can tell you about the other case, and Madam Prosecutor, because it's a domestic violence, is everybody went to jail. The allegation was that her boyfriend,
Mr. Ford,
who might have started the fight with her, I don't know, I wasn't there, but did have a gun, and that gun was confiscated, and that after he struck her head on the sink and they had a fistic encounter, that he pulled a gun on her, and she grabbed the first thing and held a knife and just held him at bay and asked her brother, who was 12, to hurry up and call the police, and asked him to stay and not to leave. When the police got there, they took his gun. Everybody goes to jail. Somehow he went to misdemeanor. And she's here with a potential felony from 2001, which is 2 years. And I don't know what's going to happen, but if everybody pleads the fifth, who knows what happens?
Right.
I know that he contacted me and was very apologetic, and it was all my fault, and can you please help her get out? And I started it, and I pulled a gun on her, and I shouldn't have pulled the gun. All bad conduct, Judge, but it's not in front of your Honor. I tried to make it happen on February 21st so they could speak with him. So what we have today is a young lady with no record, with an 8-year-old with a degree. She's still trying to do something with her life, and with first offender treatment. If she messes up, then we don't care what happened at the window, because you can give her 20 years to serve. And if she does everything she's supposed to do, then she can answer an employer or a law school. I don't know what you call them now, the people that help you get in law school, that she doesn't have a conviction. So what I was, and I always talk about this because in Georgia, you know this, you used to be a prosecutor, we have a charge of pointing a pistol at another. It rarely gets used. At least you don't see it too much down in state court at all. Sometimes you see it in misdemeanor court at the City of Atlanta Municipal Court as some type of disorderly conduct. But today's the day where we can ask the court if the court will consider a 5-year probation, anger management evaluation, family violence intervention course, no drugs, no alcohol. I don't think that's a problem, but I always like that when somebody, if you remember Judge Bodiford, he would say in his pleas, he'd say, no alcohol, not a drop. He's a big fan of that when you're on probation. No further violation of the law. And obviously no contact with Mr. Chestnut. I think he would say that there hasn't been any contact.
it sounds like it was stranger on stranger, so
Right.
it doesn't seem like an issue going forward.
And stay gainfully employed or in school or a combination of both. And any other conditions that the court would deem sufficient. I'm all for second chances, Judge, and I would also be asking if the court does give her first offender I think the plea that I need to make to the court is that the public's interest in what happens today is outweighed by her interest in having this case sealed if the court grants that at this point under 42-8-62.1.
So that's not happening right now anyway. Expungement is a ways down the road. That is a great opportunity if it presents itself, but we don't expunge before things are done. So
I didn't mean the restriction or that.
no, I understand. I'm just,
But the-
mom keeps talking.
Okay.
Be quiet.
But I am very sensitive to the fact that she understands. She this is a way, because we tender the plea, the court accepts the plea, and there she is on that slippery slope. If she does everything she's supposed to do, then she technically can be without record. It's the same as going in front of a jury and getting an acquittal. It's an acquittal.
It is much like an acquittal.
Um,
All right, let me ask Ms. Benton a few questions, and then if there's more you want to add,
Right.
I'm happy to hear that. Ms. Benton, what's your son's name?
Logan.
Logan? Mr. Ford is not the father?
Yes.
He is the father. So you and Mr. Ford are going to continue to interact. What is the status right now? Do you have is there a stay away as a condition of your bond and his bond to not have contact, or how does that work?
It was a no contact order in court when we did the bond hearing.
Okay, so do you get to see, does Logan live with you? Yes?
Yes.
Okay, how does Mr. Ford not get to see Logan?
You see him all the time.
Just someone has to get Logan to Mr. Ford, so you and Mr. Ford aren't interacting.
We do different school days.
Mhm.
Yeah.
Okay, all right. What is the second degree you're getting?
Right now for business.
And is that at West Georgia also?
No, Atlanta Tech,
What do you do for AT&T?
customer service.
Like Mr. Chestnut?
Oh, no. I'm working from
Is it virtual, like you're at a computer doing something, or do you go to AT&T?
2 days in at the corporate office and 3 days at home on the phone,
Where's the corporate office?
downtown on West Peachtree.
Okay, give me 1 second. Am I in trouble? No? Okay, I'm not in trouble. Logan's primary residence is with you.
Yes.
Okay. Who else is in your household besides you and Logan?
No one.
Just, you guys have your spot,
Yes.
not Mr. Ford there.
No.
Okay, all right. Do you have any questions?
So if you were to accept the first offender, how long would that be removed off my record?
So let me talk to you about first offender. It's primarily an opportunity. If I sentence you as a first offender, then there's no conviction on your record.
Okay.
It's not a conviction. You would be a first offender. And as long as you're on probation, you're what we call a first offender probationer. So even though you don't have a conviction, you're under sentence so that I can impose conditions like whatever I'm going to talk about. But if you successfully complete that probation and it gets terminated, then your lawyer asks for what's called discharge, first offender discharge. It's a document I sign, and that makes it all go away like it never happened. That's when you can look for expungement. But in the interim, if you're trying to go to a different school, you're applying for a job, you don't need to check the box about being a felon, nor would it show up in any employer or educator inquiry that you had a felony history, because you don't if it's first offender. But in terms of things being expunged, that's only after you've completed, ideally successfully, your sentence. So that's the benefit of first offender, all that stuff I described. Do you feel like you understand that?
Yes.
Okay, there's a risk to first offender though. Let's assume for a moment that I follow the state's recommendation and have it be at 5 years. You'll be on probation for somewhere between 4 years, what they're asking for, or 5 years, what Ms. Rockwell is asking for. If during those 4 or 5 years, you get into some other dust up and there's an allegation that you've got a gun, because you can't have a gun while you're on first offender probation, You get arrested with a gun and the state proves, and it's not a trial, a probation revocation hearing, there's no jury, and the burden of proof is simply a preponderance. So if I see video footage of you with a gun in your hand, that's more than a preponderance. Not only could I revoke your probation, but as Ms. Rockwell was describing it, it could be kind of lights out where I could resentence you because you've already pled in this case.
Right.
And I've got that whole range of 1 to 20. And she said you could send Ms. Benton away for 20 years. I'm not going to do that unless what the evidence showed is you shot someone. But if there's evidence that you're rolling around with a gun, dangerous for Logan and not legal for you. And that would be the kind of thing where you could lose your first offender status. So you'd instantly become a convicted felon and you could go to prison for up to 20 years because that aggravated assault that we're talking about now with only a 5 on it goes all the way to 20. So first offender can be real risky for some folks. Maybe not you.
You won't see me no more.
Okay, well, it's the folks who say that for whom first offender is usually a good fit. But for folks who are still out there wanting to scrap it up or do this craziness, first offender is often a bad idea because Ms. Rockwell makes money. You need her again, but you don't want to be coming back as a
But
first
I don't
offender.
want to keep spending money either.
Okay.
So,
All right. Do you feel like you understand the risks and the benefits of first offender?
yes,
And you want to be sentenced as a first offender?
yes,
Okay. Do you have more questions about first offender?
no.
All right. Ms. Rockwell, do you have anything else you want to share?
I think that's it, Judge.
All right. Ms. Benton, I find there's a factual basis for your plea. That doesn't mean I'm picking sides as to who started it or whether the window hit you or not. Simply that if Mr. Chestnut testified to the jury about what he told the police, the jury could choose for whatever reason to believe him over you. And if they did, if they credited his testimony, that could find you guilty of the aggravated assault that is really pointing a pistol, but it's also aggravated assault. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to go forward with this plea, but you've decided after talking with mom and with your lawyer that this is the way to move forward. Is that correct?
Yes,
And knowing just means you've understood all the things we talked about. And if you didn't, you have asserted yourself by asking a question of me or of your lawyer. Is that also correct?
yes,
All right. Ms. Benton, I'm sentencing you pursuant to the Probation Options Management Act. All that means is that while you are on probation, which you will be under this sentence, if you have a minor violation, what we call a technical violation, then you and probation work that out. It doesn't come back to me. You're not going to lose your first offender status. It's something not all that serious. If you get arrested again, or if Mr. Ford, well, it wouldn't be Mr. Ford. If Mr. Chestnut is able to demonstrate that you've been blowing up his Instagram with, I'm going to throw coffee on you. I'm going to close a window on your face. And there's evidence that you were the one doing that. That's the kind of thing that comes back to me. That's the kind of thing that will lose you your first offender status.
I wouldn't know what he looked like if I saw him.
Okay, good. My guess is he wouldn't know what you look like, which is going to make it real easy for you to go your happy, successful way and Mr. Chestnut to not work in customer service anymore. Do you, Ms. Benton, authorize my staff to sign the indictment indicating your plea?
Yes,
Ms. Rockwell?
Yes, Judge.
Mr. Jordan?
Yes.
All right. So sentencing, I agree with Ms. Rockwell that maybe this recommendation had its genesis, the state's recommendation, and we might resolve both cases with a 5 to serve 1. Because when you put them next to each other, you come across as a bit of a brawler. You're pointing a gun at Mr. Chestnut and you're waving a knife at Mr. Ford, and that's kind of scary. And I recognize that that is a snapshot and it's not the full story of either of those situations, but that may be the origin of that recommendation. Mr. Ford's case is not properly before me. It has informed a couple of the conditions that I'm going to impose. But if we set that aside, because it's an allegation that the state hasn't even saw fit to indict yet, and it sounds like it is a complicated mutual situation, I think that first offender is appropriate, and I will sentence you as a first offender. And I think that a sentence of 5 years probation is appropriate. The special condition of that probation, number one, is no contact with Mr. Chestnut. Sounds like that's easy, because I bet you could find him if you tried real hard, but that would be a bad choice. So,
No, I couldn't. I don't know what he looked like.
well, but we know his name, and it's just so easy to figure things out. And some guy who's touting himself as former Starbucks employee, Dwayne Chestnut, there probably aren't a whole lot of people who fit both those categories. But don't do that, because that's a condition of your probation. Don't stalk Mr. Chestnut. Number two, you'll need to complete a family violence intervention program. That's the Mr. Ford case weaving itself in there as well. You and Mr. Ford are going to have to interact going forward. I don't mean face to face, because right now it sounds like you're separated a little bit, but old Logan is a reason why you all can't be totally disconnected. And so I'm going to have you take that series of classes in a way to help you navigate, whether it's Mr. Ford or a different significant other or whatever, ways to have things be less conflictual. And I'm not saying that the Ford situation was your fault versus his. I wasn't there, and you've helped me understand that it was definitely a two-person situation. My thinking is how to move you in the direction you want to go. You said you're never going to see me again, and these conditions are meant to ensure that. I actually don't mind bumping into you outside of court. It'll be bad news if you're coming into court. So no contact with Mr. Chestnut, complete a family violence intervention program. I'm going to make it a special condition. It's already there, but no firearms. Can't have one. If you live in a household and someone else has one, they need to get it out of the house, because if there's one in your space, you can't be in that space. That doesn't mean you can't visit someone. If you're going to visit your mom and your mom's big into guns, okay, that's not your house. But if you end up living there because you got to get out of the place you're in and you and Logan move in with mom, the guns would need to move out. And that's just true as you are under this sentence. I'm not going to require an anger management course because family violence intervention program covers that. I am going to require you to do 50 hours of community service. You don't have to do that day one or week one, but that will be something you'll want to knock out as you can. And I'm setting a behavioral incentive date. That's what they call them. It's not my term, of April 25th, 2026, which is 3 years from today. If you have knocked out your family violence intervention program, done your community service, and you have had no issues with your probation, then probation would be invited to send to me early termination, discharge, get you going on your way even more completely than you would be now. If you've been a pain in the rear to probation while you're on probation, they'll say on that date, Ms. Benton has been difficult. She's always fussing about things, and whatever the issue may be, then that date will come and it will pass, and you'll have a couple more years of probation that you need to work through. Mr. Jordan, did I miss any conditions that you thought I ought to impose?
No.
All right. Ms. Rockwell, anything else?
Judge, do you ever consider waiving the probation fees?
I do, but I do that for someone like the guy who just pled, who has been in jail for a year, chronically unemployed. I have in front of me someone working on her second degree with clear visions for where she wants to go. And I don't mean to suggest supporting an 8-year-old, maybe almost all by herself, is easy to do financially, but the probation supervision fees, number one, are not all that onerous. And number two, that waiver is for folks who don't hire their own attorneys.
I understand.
Okay.
Well, just so you know, Mr. Ford was the one that got me involved.
Okay, either way.
I know it was kind of not an orthodox. This is not a DV case, this case in front of us.
It is not.
But that's what I wanted her to do, just because I know it won't hurt her.
Well, that's why I put the family violence intervention program in there. My thought is that might be a signal to the state if they're trying to figure out, well, do we do anything with what we're calling the Ford case, and say, you know what? Ms. Benton's getting FVIP through this other case. That's all we would do with the Ford case. Let's not mess with one where our star witness is a defendant in another case. So I don't know.
I didn't want you to think that I bumped my head and I got confused. So I just think it would help her even with
I think it is helpful for Ms. Benton, just period, but I also think it's an important signal that maybe we're addressing whatever concern the state might have about the Ford case. I mean, Ford needs his own treatment, but that's his business. Do you have any questions, Ms. Benton?
No.
Okay. You all should talk because it's a slightly different sentence. Ms. Rockwell didn't ask for community service, but you should talk and let me know whether you want to go forward with this or instead go to trial on both counts on our upcoming trial count.
What he's saying is, and I did mean to throw in there that give her some community service. I just didn't ask
Okay,
for it.
well then
but,
we overlapped even more.
What he said was, since I didn't ask for the community service and he is giving you community service, you can say, well, I didn't ask for it, so I don't want the plea. Do you still want the plea?
I'll take it.
Okay. Judge, all we need is reporting instructions, I hope.
Yeah, about those reporting instructions. Ms. Nelson, what's the best way for us to handle that since we don't have probation?
Judge, if Ms. Rockwell can get the client's contact information, I'll make sure that probation gets it.
Okay, so Ms. Benton, normally you would have heard that voice from the sky from a probation officer who would say you need to report. Your address, is it in Fulton County?
My mom address.
Well, you said you and Logan live.
But I got anything that go to her mailbox, it comes to my email.
Okay,
and she's never moving. I move, so I just always.
That's okay. It's where you live that determines what probation office what county do you live in?
14.
Okay. So the probation office is like 2 blocks from here. I'm not giving you the reporting instructions. I'm just letting you know. Ms. Rockwell's going to get your information to probation and probation will contact you, but you will need to report to this spot on Memorial Drive, not far from here, in a few days. I don't know the specific day. They'll let you.
That's from the city jail?
Yes.
Yeah.
Okay.
276 Memorial.
Yeah, 276 Memorial. Right now, they're not expecting you because no one from probation was here, but they're going to get you in the system and there'll be a date where you need to show up. That's your biggest date that you've got coming up, because if you miss that, they're going to take out a warrant. I'm like, what are we doing here? You got to plug in with these folks. That way you'll get your officer assigned, and probation for you, it's just going to be checking in, making sure that you let your officer know where you are if you move, for example, and then taking care of these few requirements. But you do need to get the ball rolling with probation. So someone will be contacting you soon. Don't dodge them, because the burden is ultimately on you to make that connection with probation. If a couple of weeks have gone by and you swear up and down no one from probation has been reaching out to you, let Ms. Rockwell know, because it may be that you think it's spam or it gets filtered out, and they're doing what they can to reach you based on the information Ms. Rockwell gave them about how to reach you. Okay.
Okay, so question, how do I go about traveling? Because I fly a lot. So do I have to
So
report
someone who
that?
didn't want to pay the probation supervision fees flies a lot?
Fly a lot.
Okay.
I don't pay to fly, I'm on my auntie flight benefits.
So if you're going to leave Georgia, you need to get approval from probation in advance. If you fly a lot to Brunswick, that's okay. If you fly a lot to the Bahamas, it's not that that's bad, but you need to get approval in advance. So you don't come back from the Bahamas saying, hey, here's my passport, because that's a violation of your probation. If you leave Georgia without approval, that's a violation of probation. Not the kind where you come see me, but if you keep doing it, they're going to say, hey, Ms. Benton is not complying, and there'll be consequences for that. So feel free to fly a lot, but get approval in advance.
Okay.
And that's something you and your probation officer will work out. If that person is comfortable with how you're doing, it may be that you just send your itinerary and that person says, looks good. They may be reaching out to me.
And so if Ms. Nelson could just email me a copy of the disposition, and I'll just tell mom and everybody, if she hadn't heard from me, if I get hit by a bus or if I hit the number and go to Tahiti, just come back to this courtroom. I don't want there to be, we never have no probation with reporting instructions. So I don't want there to be any disconnect. She's the one on probation.
Whoop. Hey, Ms. Tucson just joined. Hey, Ms. Tucson. That's Miss Tucson. Hey there.
Good afternoon.
Can you give reporting instructions to Ms. Benton?
Absolutely. Ms. Benton, may I have your phone number and what county you live in?
678-761-2973 in Fulton County.
Do you know where probation is?
Yes.
Okay, it's 276 Memorial Drive Southwest. Could you repeat your phone number for me one more time? 678
761
761
2973.
2973. Okay, I'm gonna call you when you leave court to just verify reporting instructions. I'm gonna have you report on May 11th at 8 a.m. And if Ms. Rockwell would like the reporting instructions, I could email them to her as well.
Thank you so much.
Okay.
Just like that, you got reporting instructions. Now we don't need to worry about it anymore. May 11th. Okay. That's it, Ms. Benton. This is an opportunity to put at least one of these two situations behind you. I don't know what's going to happen with the Mr. Ford situation, but this is a way for you to show whether it's you or your mom or whomever. I don't know what that situation was, but we're going in a different direction. Hope it goes well. That's it.
Thank you, Judge.
Thank
May
you.
we be excused?
Yep.
Thank you, Your Honor.
Okay.
That's it. I gotta get my key.
Okay. Oh, she's gonna call me later. She's just gotta go get a bag from school.
Okay.
Thank you, Judge.
You're welcome.
All the good form.
All the good forms.
You really did.
Don't take them all.
No, I want to see if you change somebody's address.
Okay, so we have 31 minutes before I have an emergency TRO hearing. Are we going to be able to sort out Mr. Walker's situation?
We are actually not going to do the plea on Mr. Walker today. I'm working on a couple of more things for him. If he does have to return, if we do get a plea worked out, we were wondering if he could appear virtually for just the plea.
Sure. Is it likely to be a situation where the state is seeking
Yes. the
time?
state's No. The
No.
state's recommendation is a out of custody recommendation.
Yes, but
And I don't think that will change.
okay. What Mr. Walker needs to be ready to do is to be here for a while, because Ms. Tucson has educated us now several times. Transferring supervision to another state isn't a snap of the fingers. And so I can authorize some out-of-state travel and whatnot. But we had to do this funky plea recently where we actually didn't finalize the plea because it was closer. It was like Tennessee or something, but the guy had to figure out when he could be back here for a few days, because you have to report to probation and fill out all your interstate transfer stuff, have some money and copies of reports and whatnot. I'm happy to be flexible with how we structure that, but the more planning in advance, Ms. Feely, you and Mr. Walker can do so that we don't, wait, what are you talking about? I was going to fly right back. Okay, so Mr. Walker is on.
Position 11 in the afternoon calendar.
No, I'm looking at that. Yes, thank you. So he's on the June calendar. So you've got a little while to sort this out. Mr. Walker, you will have to, if you have not resolved your case, you'll need to come to Georgia anyway for the call of the trial calendar, or in connection with that trial calendar. That's not till June. So there's a month plus some days to see if this can be worked out. I don't mind taking the plea with you is Colorado home now? So you appearing virtually for the plea, it just at some point you'd need to come at some point pretty soon after your plea. You need to be back here for a few days, and Ms. Feely can help you figure out the number of those days to work through probation, getting situated, and figuring out how to transfer supervision to Colorado, assuming Colorado would accept it. I think they would. These charges, they're not happy charges, but they're nothing that Colorado would say, oh, we can't supervise someone like that. Okay, so Ms. Feely, I guess the onus will be on you to figure out if it's going to be a date in advance of the trial calendar to line up. Zoom we can do whenever because it doesn't involve the jail. So it would be finding 30 minutes on a calendar where we could connect Mr. Walker and you and Ms. Willingham.
Sounds good.
Okay, Ms. Willingham, anything else on Mr. Walker's case? Okay, so your recommendation is not one that involves custody, but there's something about a non-custody recommendation from the state that's creating a gap with the defense.
Yes, this is a
Okay.
2019 incident date, and he used his first offender on a misdemeanor.
Oh.
So we're kind of trying to see what
Got it.
collateral consequences are going to be.
Got it. That's complicated. All right. Well, I hope it was a good misdemeanor to make guys into a first offender. All right, Mr. Walker, when do you fly back?
I haven't got my flight back. It'll be sometime this week.
Okay, when you come here, do you have friends or family you stay with, or?
I have a friend to stay with.
Okay, all right. We'll stay in touch with Ms. Feely. She'll let you know what's next. You're welcome. I think that's it. Anything else from Mr. Jordan, Ms. Willingham? Nice day in court. Ms. Feely? Let me look at tomorrow. Drug court in the morning. We've got a Zoom calendar in the afternoon. So I will see you all. We'll have to stop at 3:30. So if there are things you really want to knock out, hey, this could be a plea or that, let me know and we'll get those at the outset. But we'll have to stop at about 3:30 tomorrow.
Yes, Judge.
All right. Thank you.
Thank you. Judge, they gave me my new assignment. Unfortunately, I won't continue to be before Your Honor. Looks like Judge Edwards, Judge Richardson, and Conocer.
All right. You'll survive that.
Yeah.
Most of it.
Most of it.
You wanna see something funny, Judge?
Sure.
Remember the note about O'Neill and all?
Yeah.
So one of the family members did this.
What? Why? That's strange. I mean, they just were off by a month. I don't know who told them it was today, but it's,
Yeah, they probably thought.
they heard the 25th and anyway, a month from now.
And this is Mr. The interpreter.
Oh, Mr. Lares.
This is his,
Okay, should we take it back into chambers?
I will.
Yeah, let's do that. And then just tell Michelle and she can reach out to him. He can come by and get it. you.